Hear ye. Court of Appeal of the State of Michigan is now in session. The Honorable Colleen A. Bryant, the Honorable James Robert Redford, and presiding the Honorable Anna Levitt. All persons having business herein draw near to the attention and they shall be heard. God save as the state of Michigan.
Well, good morning. Okay, well, I think we could do better, but okay. So on behalf of myself, Judge O'Brien and Judge Redford, I want to welcome you to the first day of our Detroit case call. We're panel number 2. There are some familiar names on our docket today, and we know that these cases are important, and I assure you that we have been diligently working on these matters. We've had the benefit of your briefing and also the benefit of the work of our research division as well as our chambers. As you can see, we are familiar with the relevant facts and the case law, so I'd ask you to please focus on your salient points, keeping in mind our role as an error-correcting court. Today, we're also hearing some matters involving sexual assault victims and children. Because these proceedings are being recorded and broadcast, we ask that you please substitute initials in lieu of using a victim's, a petitioner's, or a minor's full name in those cases. Just a few other things. For those of you that are here for the first time, if both sides have oral argument, each have a half an hour. I don't think anybody here will need to use up their full time, but I'm happy to help you keep time and happy to reserve time for you for rebuttal if you are the appellant. If only one side is endorsed, there's 15 minutes of oral argument. So with that, I'm going to call our first case. It's item number 1, docket number 370009, People versus Jennifer Ann Galvin.
Good morning, Your Honors.
Good morning, sir.
When this conviction was up here before an appeal of right, it was a 2-to-1 decision. The dissent, unfortunately, didn't bring a friend. The dissent was by Judge Shapiro, who said, amongst other things, or wrote, amongst other things, the uncontradicted evidence was death due to subdural hematoma caused by blows to the head intentionally inflicted that day. Nor, he noted, was there any evidence of Jennifer having done so, nor of any aiding and abetting, which of course has been expanded greatly. The preliminary examination judge refused to bind over the felony murder charge with respect to my client, sorry, saying that there was no evidence to support it. It was reinstated by the circuit court judge. So the question comes up, how the heck could she have been bound over, not bound over, tried, convicted? How could that be? And the answer is this issue. Starting out, the trial prosecutor opened with a statement that said, I got 3 theories for you, multiple choice. And she sets forth that, well, she did it. Of course, there's no evidence. She aided and abetted. There's no evidence, 0. And then the third, it's almost absurd. It says she did it because she's guilty of felony murder because her mistreatment set an atmosphere that inevitably led to the murder. Now, as far-fetched and baseless as these statements were, they were blessed by the court. It's almost as if they were a team. I doubt that. But the fact is, what the judge indicated in his instructions to the jury absolutely opened the door wide that anybody probably sitting next to Mr. Galvin would probably be convicted. What the judge essentially indicated, what he indicated was first of all, I mean, let me start the other way. The fact is, he never gave the felony murder instructions, never gave 16.4, 16.4, B. What he essentially said, and exactly what he said, as I find it, is that trying to find the exact words, I'm sorry. The exact words that he indicated were the defendant caused the death of Frazee. That is, that Frazee died as the results of the acts of defendants. It was always pluralized. The acts of the defendant, absolutely nothing in the instruction had to do with the cause of death, had to do with any legal and factual causation, had nothing whatsoever to do with it. It absolutely opened the door, the proverbial door.
I believe. Judge
Counsel,
Redford
may I ask
has
a question?
for you.
Sorry.
No, no worries. Was the jury charged on both a principal and an aider and abettor theory?
Yes.
Okay. If the defendant, either defendant, had aided and abetted the other in committing some type of grievous child abuse that resulted in these injuries, would that be enough for the jury to return a first-degree felony murder conviction?
Forgive me again. I am wearing hearing aids and I do hear you, but I don't get the question.
Okay. If it's an aiding and abetting theory of prosecution, if a defendant aids and abets a co-actor, a co-defendant, with committing the underlying felony of the serious child abuse, and I'm not saying the correct statutory word description of it, is that enough to meet the state's burden for the causing the death under the felony murder statute?
Absolutely not.
Okay, why?
The cause of death was clearly stated by the medical examiner.
Yes, Dr. Spitz.
Right.
Yep.
In no way whatsoever was there any factual, the slightest factual aiding and abetting? The only evidence was that she went out, that she went out to the car to go pick up her other child with one of her other children. And while she was there, he comes out at the doorway anyway and says, come in, you know. And she goes in and finds the result of what he did. Of course, he tells her, oh, she fell. That's what he tells her.
Right.
And she's a registered nurse. She gives everything she could. She gave, in any event, and called 911. That's it. I don't know. I mean, no matter how extended aiding and abetting has been, there's nothing there to say she aided and abetted.
Right. But if the jury didn't believe that that's how it happened because of, let's say, the testimony of the paramedics and the first responders who said that it didn't seem as if
You know, that's
the
an
time
issue
period,
as well.
I know, and you've briefed it. I understand your arguments on that. But the jury had that information. If they concluded that, you know, she didn't call right away, does that add some circumstantial evidence that perhaps it is not as she reported it?
The jury was never instructed about what it was that she could possibly have done. The idea of saying, I don't believe some testimony that was given is not a basis not a basis of evidence.
Right, but there is testimony from the medical examiner that said, well, it is difficult to put an exact number on it, but certainly there were an abundance of injuries. 20 or more is probably being conservative. The injuries consisted of various bruises, abrasions, which are scrapes of the skin. Bruises involve the face, the forehead, the scalp. Some of the injuries, in fact, many of the injuries were visible externally on the scalp, and they had an associated deep scalp injury as well. And he continues on. Those were not the cause of death, but there's certainly an indication there's a lot of things happening to this child that were in contravention of laws of Michigan.
I don't think we should ever lose track of the issue itself, and that is the instruction to the court. This has died as a result of the acts of defendant, period. I've seen too many situations of finding of guilt where there was no evidence of the crime. The jury wasn't charged with the crime. Yes, certainly a jury can speculate and say, you know, I really think she did it and he is taking the blame. Sure. They could say, you know, I think that they both were there and they both beat her up. There's no evidence of that. The idea of saying if they don't believe her for some reason, her testimony, if they don't believe her, that's not, as I commented before, that's not a basis.
So your position is even if they gave credibility to she didn't call right away, or it wasn't exactly as she described it, the prosecution still failed on an essential element. That's your position.
Yes.
Okay.
It's critical to know that this instruction in no way fairly presented the issue to be tried. Importantly, when the judge charged in this manner, it allowed the prosecutor, as I mentioned, to go for it. And the prosecutor did that and did it effectively. And not only did it effectively, but violated every principle that a prosecutor and an attorney should have. That door is open and the prosecutor says, you don't have to decide whether or not it was Jennifer Galvin who struck the last blow. Not as jurors. Some of you may find because he admitted that he was the last person with Frazee and he lied about what happened, that he's responsible, he caused the death. But the real issue, ladies and gentlemen, the real issue is that either defendant offer any assistance to someone else who committed these crimes. This result was inevitable. It was a natural and probable consequence of their actions. Skipping, her death was a natural and probable consequence of this systemic child abuse she suffered. Now, there was no objections to the charge, to the argument that clearly establishes ineffective assistance of counsel. As far as the quote experts who treat people, this idea of drying of eyes and whatever, this is not an issue that people with some experience of addressing people who are injured. This is a medical issue, a detailed issue. Again, ineffective assistance of counsel. I mean, I certainly rest with respect to and rely on the briefs with respect to the other issues. In closing, I want to indicate that in no way did the prosecutor in any manner at all address what is called a waiver, or what the prosecutor calls a waiver, because the attorney, regardless of the errors that he made, because the attorney agreed to or expressed approval of the jury instructions. I believe I cited both cases, Mitchum and McGraw, both decided the same year. And both Supreme Court cases. And what they say there clearly is that if you don't address it in your brief, you can't argue it. That's the law. And there was a dissent there by Justice Corrigan. Saying that it's okay if you don't, if the prosecution doesn't file a brief. but even she had no dissent with respect to, in the event that there was a dissent, she had no argument whatsoever as far as whether or not in a brief, if it's not cited and briefed, that you can't argue it. And I don't know if I have any time left, but whatever it is, I'll reserve it.
All
Any
right,
questions? Other? No, thank you.
nothing.
Thank you.
Good morning, Your Honors. It may it be the court. Ashley Stone from the St. Clair County Prosecutor's Office on behalf of the people plaintiff appellee. I think what's interesting is defense counsel sort of opens up with saying, well, how could she have been convicted? And I think when you look at this record, that's a fact dependent inquiry. And the jury and the majority on direct appeal rejected the version of facts that were presented by the defendant at trial, and that I think she continues to present, and otherwise credited the other evidence that was on this record.
Right, he acted on his own and there was no time for me to be involved in any of this.
Correct. There were even other things where she says she wasn't at the house or couldn't have possibly been the one to strike this injury, which is contradicted by Dr. Spitz's testimony that that injury could have happened between minutes up to 8 hours within sort of that head blow being struck. There were other things about the defendant's testimony that were incredible. She denied making statements.
Hold on a sec.
Mr. Halpern, are you having difficulty hearing? Okay. Do you want to move your chair so you can, maybe that'll help you be able to hear the argument being made?
I'll try to speak up as well.
All
I'm
right.
in the same department as you on the hearing piece, so.
Okay. All right.
And just that there were other things about the defendant's testimony that were incredible. She denied making statements about calling the child the devil or speaking about her in very derogatory and cruel manners that were otherwise contradicted. So the jury,
There was an abundance of evidence here regarding child abuse. And for an extended period of time and a number of witnesses that saw injuries on this child.
I would agree, Your Honor, and I know we've briefed that extensively. And so I say that all to say that when we turn now to the current appeal, where the question is, did the trial court abuse its discretion in denying the motion from relief from judgment? Just because of sort of the factual mental gymnastics we have to do, we have to evaluate the merits of the claim. But the instructional error claim, the argument now is that the error was so critical in how the jury was instructed about felony murder that it confused the jury, misled them, or otherwise unfairly presented the evidence. And I don't believe that to be the case. So we look at this record, I think the jury had all of the facts and evidence that they needed to consider the charges. Judge Redford asked the question, and my answer would be yes, that in aiding and abetting the principal offense of either child abuse or torture, that is enough for them to convict on the felony murder. And I think that's exactly what they did here. Defendant Jennifer Galvin.
You have to have, if that's your theory, do you have to have more specific instructions than the ones that the trial court gave to the petite jury in this case?
My answer to that is no. And the reason for that, I think in terms of the defendant says there's no facts about aiding and abetting. Obviously, we disagree sort of based on, the discussion on the facts we've had in this case. The theories about how the defendant, whether she was a principal offender or whether she aided and abetted, were all materially identical proofs. It was longstanding child abuse. She either participated herself or she knew about it. There was evidence on this record that the defendant, the co-defendant, Joe Galvin, had a history of abuse with his other children. There was extensive evidence about the, I think, very cruel and harmful child abuse that was inflicted on this child based on the medical examiner's report. Those were all things she would have known about. So whether she's aiding and abetting by not giving aid, by not stopping the child abuse, by not calling for medical help earlier, or whether she's inflicting the injury herself, those are all materially identical proofs. And so I don't think we need a specific unanimity instruction, which is one argument defense makes, that, hey, there should have been a specific unanimity instruction about the felony murder. I don't think that's needed here because all the proofs are materially identical. Aiding and abetting, I believe, is a viable theory, and I don't think you need any more specific instruction about that. I think the acts of defendant's language is adequate for that. Felony murder instruction requires them to find that the defendant caused the death, so I don't think we have a causation break, as is otherwise argued. And I think the other argument that defendant makes in terms of the instructions not being adequate, in the briefing, there's mention of giving instruction 16.4b sort of about causation. And again, I don't think that that's helpful either. That's sort of, the use note for that instruction is to give it when there's a question about whether or not the crime, or excuse me, the murder occurred, during the perpetration or the attempt to perpetrate the crime. And I don't think we have that question here. Certainly this child's death was caused by blunt force trauma to the head. I think that that's undisputed, really. And that certainly happened during the perpetration of one of the crimes. We don't have, I just don't see how that instruction would have been helpful.
Did the jury, in order to return a true verdict, did the jury have to believe that this defendant struck the blow that caused that blunt force injury?
No. No, I think this jury could believe she struck the blow that caused the blunt force injury, or that she otherwise knew about that blow coming from Joseph Galvin and assisted in delivering it or in covering up or in failing to get that child help in a way that may have saved her life. Any of those things would have been enough to make her culpable. So in terms of the appeal now, I think even if, as we stand here today and sort of Monday morning quarterback it, if we find that there was some more precision or something that maybe could have helped, that still would not have required the trial court and doesn't require this court to reverse. People versus LaFew from 2022 makes it very clear that even if instructions were imperfect, reversal is not warranted so long as they fairly presented the issues to be tried and sufficiently protected the defendant's rights. And here the felony murder instruction did that. Again, I think from the extensive facts on the record and from the fact that they convicted on all of the underlying predicate felonies or principal offenses, this jury was not confused about what they felt about this defendant's culpability. Additionally, turning to just briefly the second issue regarding the testimony from the first responders. I don't see that as being expert testimony. I think that was adequate lay opinion based on some of their training experience, but also their observation that this child looked like the injury had not just occurred. There were signs that she had been injured for a while, including the drying of the eyes, the color of her skin, the fact that she was barely breathing. All of those things were part of the testimony. And in terms of
based on their experience and training.
Yes, Your Honor. And I think it's important to note too, because one of the claims is that it was ineffective assistance counsel to not object to that, and that should get us over the procedural bar in terms of the motion of relief from judgment. Defendant's trial counsel did object to, I believe it was witness Ratz's testimony, and that objection was overruled. And so really, to say that they didn't object, they did on one of those witnesses, I think sort of read the room and maybe didn't make the second objection when it came to witness Ulrich's testimony. But ultimately, I don't see how they can meet the prejudice requirement either, because you had testimony from the medical examiner, Dr. Spitz, consistent with that this injury was not consistent with the fall in the bathtub, the story that Joseph Galvin gave, and that it could have been inflicted more than mere minutes for up within 8 hours of the death. And so having that testimony as well, I don't think the EMS or first responder testimony, keeping that out will ultimately makes a difference in this trial. So they can't show prejudice in terms of the ineffective assistance of counsel claim. With that, Your Honors, I think I will rest and rely on my brief, but I am happy to answer any other questions this court may have.
I see none.
Thank you.
Thank you.
Do you have rebuttal, Mr. Halpern?
just, um, I don't see how. Take that back. You just cannot get around the instruction. The instruction was unconnected with the law. Everything that went on during that trial was pluralized.
Was there a motion to sever? Was there a motion to sever the trial?
No, no,
Does that impact our review? Does that impact our review? Should that impact how we look at
Of
it?
course.
In what way?
Oh, I got a lot of shoulds. I mean, in what way?
If no one moved to sever the case, and part of the now post conviction, post direct appeal, post denial Supreme Court review, post habeas denial by the federal court, if the objection is everything was referred to in the plural, if counsel didn't make a motion to sever, how should we be addressing that issue?
Again, I'm positive that the issue that was presented here has to do with the instruction. Pluralizing and whatever. She was anchored to her then husband. She was anchored to him. And she went down with him. And the speculations that can take place, it's not what jurors are supposed to be about. And as is stated by appellate courts all the time, jury is presumed to follow instructions. I as a defense attorney, I've 68 years. I haven't used that, but the prosecution does. Or the prosecution says, and the judges as well, in denying, well, we have to look at the whole thing. We have to look at everything that the judge said in his instructions. And when you look at the overall, it's covered. There's nothing covered here. There's nothing to indicate that that the instruction covered the most essential elements. And that's why the prosecution was able to say all these terrible things. She was absolutely tied to him. I mean, the idea of being able to say, it fits the instruction. You don't have to decide whether or not it was Jennifer who struck the last blow. You don't have to, her death was natural and probable consequence. It absolutely just, she went down with she went down with him. And he, of course, has committed, perpetrated the most horrendous, unforgivable crime. Nothing wrong with what the jury did. They followed the instructions to a T. I don't know who aided and abetted in terms of, there was no aiding and abetting here, but there certainly was aiding and abetting when the judge charges them in a manner that has nothing to do with felony murder.
Thank you both. The matter is submitted. We're going to call our next case, item number 2, docket number 372121, People of the State of Michigan versus Adam Richard Williams.
Morning, Your Honors. Michael Brown, for appellant. May it please the court.
Morning.
Morning.
You have an amended brief. Yeah, we did correct the issue 5 heading in that. That's the only
Right.
correction that I wanted to say. Thank the court for allowing us to do that.
Right, we have it.
Thank you.
Thank you. Regarding issues 1 and 2, important issues, we asked the court for the relief that's requested, but I really don't have anything to add to issues 1 and 2 unless the court has any questions. I'll stand in my brief in regards to those issues.
Okay, I see no questions.
Richard, thank you. And regarding the sentencing issues, just a few remarks.
Okay,
Mr. Williams, he received a 312-month minimum term, fell outside the guidelines range of 171 months to 285,
right.
and no prior record employment. Court knows all of that already. It's in the briefing. His relationship with SS, the complainant, was long, intimate, turbulent, continued for quite a while. Mr. Williams had prior wives and girlfriends who weren't happy with him. That's clear from the record. None of them accused him of violence. That's the background. And then we have the sentencing hearing where the trial court relied on victim impact statements that contained hearsay. The complainant quoted Mr. Williams' minor son,
Right.
comparing him to Dahmer. So we question whether that was fair. That's outlined in the brief. Guidelines issues, we address those. They don't, even if were to be correct about all of them, it would change the range. However, it might, I think it's still relevant to when we look at the proportionality of the sentencing. And then finally, something new, for the counsel at page 43, I don't say takes exception, that's a little strong, but he correctly notes that that I cite the age crime curve at page 40 of my brief, but I don't cite any authority supporting it. And that's true. And actually, at the time, I'd looked before, there was no authority. I'd looked before. I never found any published case in Michigan citing the age crime curve. There were 4 unpublished cases. 3 of them were mine because I think I'm the only attorney that uses the age crime curve. I don't know why, but on April 10th of 2025, so it was after my brief was filed, a little bit before prosecution's brief was filed, not long before, the Michigan Supreme Court did in People v. Taylor and Zernicki. And I still only have the slip opinion, but at page 7, if you look at that opinion, the slip opinion at page 7, they do cite the age crime curve favorably, sort of, adopted. It's an established phenomenon. I mean, I can recall when I was in 7th or 8th grade, we had a science fair. I think everybody did back then. And the classmates were putting cigarettes next to house plants, that type of thing. But I had an uncle who had a PhD in criminology. And I remember we did a paper. I did my science project in criminology, and we did the age crime curve. So it goes all the way back.
So we
Really
should have
beyond.
known. We should have known then. That would be your life's calling.
Yeah, well,
So,
yeah, I should have. Yeah. And so it's established part of science. It's and I'll leave it at that. Unless the court has any questions. Okay.
I
Thank
see
you.
none. Thank you.
Good morning, Your Honors. May it please the court, Jack McIntyre appearing on behalf of Plaintiff Appellee, the people of the state of Michigan. So like brother counsel, I'll significantly limit my argument. I'll just address the hearsay and the victim impact statement. I'm not aware of any authority that says a victim impact statement cannot include hearsay. And I also believe that the court did not rely on that hearsay in imposing sentence. And if you look at the portion of the judge's sentence that is quoted by the defense, it's clear that he's responding to the defendant's claim that he's a loving and devoted father. And as an aside, the court is saying the court doesn't accept that you're a loving and devoted father. And here are the reasons why we don't accept that. In part because the defendant himself, and this was attached to his sentencing memorandum as a exhibit A or 1, wrote a letter about how the detective was corrupt and that he was trying to have sex with the victim, et cetera. And the judge was saying these are not appropriate things for you as a father to say to your minor son, in effect saying, when you defendant argue that you being a good father should be a mitigating factor, I'm not finding it to be a mitigating factor because the record evidence does not show that you're a good father. It's as simple as that. And I will also just point out that the sentence is proportionate and it was a very modest departure. I won't belabor all the reasons why the departure was appropriate, but those are set forth in my brief, and I'm happy to answer questions about any of those points.
I do have a question about OV 12
Yes.
and recognizing the fact that it doesn't make any difference here. And that's your argument, but can you tell me why OV 12 was correctly scored?
Yeah, so OV 12 was scored because there were 2 separate offenses. Those additional offenses were felonious assault and unlawful imprisonment. The felonious assault was when defendant used a bat that he had brought to this assault. He told the victim that the notches on the bat were for people who had, effed with him, that this was his language, insinuated that he had knocked somebody's teeth out with the bat, insinuated that he had killed somebody with the bat, stuck that bat into her face. Any person in that situation would reasonably fear an imminent battery.
Okay, and how was it that my reading of the transcript is that the prosecutor tied those actions as being the force and coercion that could also, or also being armed with a weapon that supported the CSC?
My response is that for both home invasion and for the CSC, the element is armed with a weapon, not committing a felonious assault with the weapon. The defendant entered the house with the weapon. That gives the basis for the charged offenses. In addition to that, which was not required for the jury to find the defendant guilty of the charged offenses, he assaulted her with that bat, as I just described.
Okay, so that there was a cutoff and the bat had nothing to do with the.
Well, there was no cutoff because as I'm reading the elements of the charged offenses, he committed those offenses while armed with a weapon. It doesn't mean committing an assault with the weapon, but while armed with the weapon.
Okay, and what about the fact that it's force and coercion? Where's the force and coercion without the bat, which is what the prosecutor argued it was for?
Well, the presence of the bat was for force and coercion, but the actual additional conduct of threatening her in the manner that I described, that would be additional force and coercion. That's not required to find him guilty of the charged offenses.
Okay, and what about the unlawful imprisonment?
The unlawful imprisonment was based, I believe, the record's not entirely clear on this, I don't think, but I believe it was for the defendant going to sleep on top of her. The victim testified that he had his full body weight on her and she could not move and she was stuck there until the defendant woke up. That's the basis for the unlawful imprisonment.
All right, so what are the elements of unlawful imprisonment?
I don't recall those off the top of my head, Your Honor. I'm sorry.
Okay. All right, so if we were to find that there was some error here, what's the remedy?
I believe there is no remedy. The defendant is not entitled to resentencing because this doesn't change his guidelines, and I don't believe that there is a remedy prescribed by law when the sentencing variable is incorrectly scored and it does not change the guidelines. I'd also point out that this is reviewed for clear error and a plain. Don't believe that the court plain error.
One follow-on. A week or two ago, the Supreme Court issued a sentencing opinion and addressed Francisco. Are you familiar with that case?
No, I'm not, Your Honor, off the top of my head.
All right, never mind. Thank you.
rebuttal, Mr. Pearl.
Very briefly, I'll just go back very briefly to, the use of hearsay at sentencing. I agree that that is why the trial court used the hearsay that was put in front of it. Mr. Williams was saying he was a good father. I don't know if he is or not, but the court's entitled to its opinion. And the court's entitled to reject Mr. Williams' position that he was a good father. But when the court did so, he did so based on the hearsay which the defense objected to. Hearsay can be used at sentencing. I agree with the prosecution. There's no rule barring hearsay, criminal sentencing, but the law also says that the defense has a right to object to it, make a meaningful objection. And when they, in the case of the letter that the court referenced on its own, didn't have it, it can't make a meaningful objection. So I agree with the prosecution as to how it was used, why it was used, but disagree as to whether, all of this hearsay should have come in the way that it did. That's all I have. Thank you.
Well, can you talk about the remedy then?
Regarding the guidelines there, well, first,
You've asked for us to remand to enter a corrected SIR. Do we even have to do that if it makes no difference? Is it moot?
I don't think the law is very clear on that. I've seen courts remand it for an SIR, and I've seen courts just say it doesn't matter, panels, I should say.
Okay.
I don't think the law is perfectly clear on that. That's why I've tried to argue that, maybe it should weigh into the proportion. I have seen courts say, well, you're not entitled to resentencing because the guidelines range isn't changed, but we're going to consider it. The court did depart from the range. The court did so on mistake of law, at least in part, we have to assume. And I've seen courts apply that to a proportionality review and remand for resentencing and, consider that in that context. And I've seen panels. I'm the case Your Honor was referring to, Eads.
I don't remember the name of it. It was not Francisco, but it was addressing Francisco and the proportionality within guidelines ranges.
Right.
So pardon me. Something like that.
Yeah.
Hoped, is it? Anyway, I scan read
It
it.
was just last week.
I scanned it
I
too.
don't think
That's,
I-
I just wondered if somebody
I don't think I have
understood it more than I did. There's a lot to read the last couple weeks.
Yes.
I don't think I could have anything to say on it that's going to be helpful. So, all right.
All right.
Okay, that's all.
All right. Thank you both. This matter is submitted. We'll move on to item number 3, docket number 374291, People of the State of Michigan versus Sadari Deshawn Donaldson. And we have Ms. Young joining us by Zoom.
Good morning, Your Honors. Laurel Kelly Young on behalf of defendant Sadari Donaldson.
Mhm.
And this case is primarily self-defense. And that Mr. Donaldson, he testified that they were asked to leave the party, they left the party, then his friend went back in.
Right.
And then his friend got into a tussle, and so he went back in, and his friend was being choked, and he was being, I guess, held against his will, and then he shot his gun to protect himself and his friend, and
That's what he said.
that's what he said. But there is a witness that does corroborate that they left and they came back in and there was a fight. So any questions?
I don't have any. I thought it was very well briefed by both sides. Thank you, counsel.
Thank you.
Ms. Reddy.
Morning, Your Honors. Rayanne Reddy, Assistant Prosecuting Attorney, appearing on behalf of the people. Your Honor, Your Honors, I'm gonna primarily rely on my brief here. I think that as to the first issue, remember that the court relies or the court is obligated to view the evidence in the light most favorable to the people. And I think there was evidence presented that there may have been a tussle, there may have been some touch and go. I don't think there was anything remotely close to any sort of deadly threat or danger. It was a physical tussle. And defendant decided to bring a gun to a knife fight. So I think the self-defense, if you view the evidence in light most favorable of the people, that doesn't hold water. As to the remaining, sentencing issues, I'll rely on my brief.
I see no questions.
Thank you.
Do you have any rebuttal to that, Ms. Young?
No rebuttal.
All right, thank you both.
Mhm.
Case is submitted. Item number 4, docket number 375-304, People of the State of Michigan versus Maurice Rushton. And Ms. Young,
Yes.
it's all you.
Yes, I'm just having to change gears here. But yes, Laurel Kelly Young on behalf of defendant Mr. Rushton. And the primary issue here is that there was not an instruction for voluntary manslaughter, which necessarily included lesser offense. And what supports that is, well, the evidence shows that they were chasing him, and what got Mr. Rushton so upset was that the deceased had stolen from his car and also made disparaging remarks regarding his Muslim religion. So other than that, I will rest with my brief.
Okay, any questions? I see none.
Thank you.
Mr. Barlock.
Good morning, Your Honors. May it please the court, Brandon Barlog on behalf of the people as appellee. Just on the brief comment that Ms. Young made, I just want to note that my argument in my brief was the issue was waived because counsel agreed at the trial court that he was satisfied with the instructions, and that because Ms. Young does not argue ineffective assistance of counsel, that doesn't open the door. And I should note in defendant's brief, and I apologize on the page number, but it indicated that the jury had sent a note out, I believe I'm paraphrasing, regarding some heat of passion. That did not happen. Because the trial counsel, the only thing that he argued was that Mr. Rushton did not commit the crime, not that this case was heat of passion. So with that, unless the court has any questions, I'll rely on my brief.
I just have a question about the forfeiture by wrongdoing.
Yes, Judge.
Is there a reason that the preliminary examination testimony of the one witness would not have been admissible under a different court rule?
Right.
Yeah, I mean, I think it would have been under the unavailability, 804, I think it's
Right.
2 or 3, I think it is. But yeah, it could have fallen under there.
So, I mean, even if there was error here, even if there had been error here, how is any error, how does it result in a new trial? I mean,
That's a good question. My argument, it doesn't, because there was plenty of evidence outside of the preliminary transcript. Lots of circumstantial evidence in this case that defense counsel trial cited. So even but for the preliminary exam testimony, there's so much other circumstantial evidence, the orange goatee, the DNA found.
right.
But
And the other witness who identified him, who unfortunately passed away.
yeah,
But that testimony but his statements were also admitted under another exception.
correct.
Right, but couldn't the preliminary exam testimony of the one witness that was allowed under the forfeiture by wrongdoing theory, if the witness is unavailable because they choose to not cooperate, because they fled, because they're asserting their Fifth Amendment right, whatever, wouldn't that then make the prior testimony potentially available?
Absolutely.
If they have the same motivation for cross-examination, the same parties, you've got, a similarity and aligning of
Yes.
interest.
Yes, absolutely, Judge Ruffin. Yes. Okay.
All right. I see nothing else. Ms. Young, do you have
Thank
any
you, Your Honor.
comment?
I guess the only thing that I wanted to say is that he said that I had put something in my brief that didn't happen, and I will go back and check that because I would never intentionally put something in a brief that didn't happen. So
All right.
that's it.
Okay,
Right.
thank you both.
Thank you.
The matter is submitted. Moving on, item number 5, docket number 374486, Mark Horsey versus Richard Hobig. If I pronounce anybody's name wrong, please correct me, because trust me, with a name like Anna Koletica, I've heard a lot of mispronunciations.
Your name's easy to pronounce.
Oh, well, one would think, but that's not the case.
Good morning, Your Honors. May it please the court, John McKenzie on behalf of the appellants of Torsies. I don't
Good,
think
I got it right.
It is. I do not think I will use all my time, but I'd like to reserve 3 minutes for rebuttal if
Okay.
necessary. Just a couple of highlights on the facts. I know the courts have read the briefs and the briefs are significant.
Oh,
This property is a water property located on the South Channel. And if you're
the
not,
history is significant. This has gone on for how many
In the beginning,
years?
there was
Yes, in
light.
the beginning. 2006.
2006, there
or
was,
7, we started with the application permit process,
correct, yeah. There
and
was,
then we built it, and they will come. And when 2020,
2023, he built the bridge.
yes.
Yeah, so he had his first permit 2006. There was a contested case with the
What was
administrative
on
forum.
DEQ?
Correct. Where the administrative law judge proposed a denial of the bridge, the DEQ director
Right.
overturned that based on the facts at that point in
Mhm.
time. Mr. Hobig did not build his bridge until 2003, which is, and my client moved into the property in 2017. So there's some
When your
overlap.
client moved in, there were already pilings in the water, set, ready to go to put on the bridge that eventually becomes the subject matter of this litigation. Fair? So on physical notice of what's happening before he completes the purchase of the property. Is that a correct statement?
Mostly correct, Your Honor. The only thing that I would change is the pilings that were in the water. I don't know when they were installed, and that was not put into evidence. They were there, and there was no bridge erected for 20 years. And he,
Right, but the permits continued to be reissued, and after the bridge was in place, a post-building permit, as is authorized both by the administrative rules of the agency and the statutes of the state of Michigan, was issued to the property owner, correct? Is all that correct?
I don't believe all that's
Okay,
correct,
what
respectfully.
is not correct?
Well, first, the pilings were cut because there was supposed to be a retractable bridge that was going to be erected. And then
That's what you say, but as far as the question I have is the permits that were issued. It wasn't built within the time period the first time it was issued, or the second time, or even the third, but the department kept renewing these permits. Is that a correct statement?
yes,
Is it also correct that once the bridge was completed, a post-completion permit that authorized everything that was done was issued by the department?
yes.
Do you also agree that as a matter of practice, that is, and this isn't in the record, but that is a very common practice by the department? Do you agree with that?
Issue an after the fact permit?
Yep.
If they agree with the activity that was done, then yes, they will.
So it's nothing unusual to that. Fair?
Your Honor, I don't have the experience to tell the court that that's always done.
Okay, not
but
always,
I know
but
in this
it's-
case, they did issue the after the fact permit.
Your client has riparian property on the navigable stretch of the South Channel that the freighter traffic goes in, correct?
Yes,
If they wanted to, they could build whatever dock they wanted to that the Army Corps of Engineers and the state gave them permits for on that side of their property. Is that correct?
with probably a $500,000 investment, they could potentially put in a dock with hoist to store a boat or 2 boats there.
And fair to say that many, many properties upstream closer to the St. Mary's River from your client's property have such docks in place for their utilization of watercraft.
Yes, they do.
Okay. On that channel that your client doesn't want to build on. Yes.
There on the South Channel, there are a number of houses that have docks with hoist to store boats on.
That are on the, we'll call it the freighter
Yes,
side.
correct.
being a paddle sport enthusiast, I just go completely in the other direction when I see freighters. So I can understand the reticence of wanting to pull it in. I don't understand how your client isn't barred by either res judicata or collateral estoppel.
Sure, and I will address that for the court. So going to res judicata, I think that's the easier of the two because that is the claim preclusion. And in the circuit court case, we filed a nuisance claim. No court has ever heard that claim. I think what we're really dealing with is the issue preclusion, which is navigability of the canal. So I'm happy to address any further questions on res judicata, but that claim, the nuisance claim, was never heard.
Is that the basis of the trial court's ruling?
The basis, the trial court did deny under res judicata and collateral estoppel. The
I
issue,
thought that the judge said it was more properly collateral estoppel, but maybe I'm wrong about that.
I think he did deny under both, but he focused primarily on collateral estoppel because of the issue preclusion. And my argument is where the trial court erred is the issues are not the same in the circuit court under a nuisance claim compared to what the state of Michigan looks at the administrative forum under a contested permit hearing. In the state hearing, the administrative hearing, what the state looks at are two things. One, are riparian rights harmed, which here they're not. There's no riparian rights in the canal. We're not contesting that.
So you agree that your client has no riparian rights for the canal?
Under the case law, yes, I agree with
And
that.
that's because, do you agree that it's a man-made channel?
Yes. From the evidence that was in the record. So the next thing that the administrative forum looks at is, will the proposed activity offend the public trust doctrine? And that is a case-by-case subjective analysis where the Eagle permit officer will make a determination, will the proposed activity offend the public trust or not? And under that lens, what they're looking at is, will navigability of the canal system be harmed by the activity? And in this specific piece of property, the state said no, because the testimony in the 2008 case, which my client was not a part of, didn't own the
But
property.
his predecessor in interest that he has a direct line of title to was a party to that.
He was, Your Honor.
And the boat that he had fit underneath it, and the judge said, okay, you're not affected.
And correct. And in the 2008 case, they said the public doesn't use the canal. So we're not concerned about the public's use. And as far as Mr. Fullington, all he has is a low profile pontoon boat that can navigate the canal. So if you read that opinion in detail, it says under these facts specifically in this record, we are authorizing the proposed activity, and Hobig never built the bridge under that permit.
Yes, he did, counsel. The permit kept being either renewed or reissued. Yes?
It was reissued with different specifications over time. It wasn't the same exact permit reissued over time. And that's why the permits expire, because they have a 5-year period. If they do the work, if they don't expire, you got to go back and reapply because facts and circumstances.
And when it's all said and done, the department that regulates this on behalf of the 10 million residents of this great state gave a post-completion permit that said you're good to go.
Under the lens of Part 325 of NAREPA, yes, because that two-pronged test is met. And I've gone round and round with Eagle in this case and other cases, and their response to me is they will not become involved in private property rights. That's reserved for the circuit court. And if you look on the face of the permit itself, the permit subsections G and H specifically state on the permit itself, I'm going to read subsection G. This permit does not convey property rights in real estate or material, nor does it authorize any injury to private property or invasion.
Right. You quote that in your brief.
Okay.
All right.
So-
So hold on. Go ahead and answer.
All I was saying is then under subsection H, it says that any person whose private property rights are harmed may go to the circuit court for relief. And that's what the Torsies did here.
Okay. Could your client's predecessors in interest in the chain of title have sought circuit court relief back in the day?
I believe they could have filed a nuisance claim as well, but they didn't do that.
Okay, since they didn't do that, why do you get to do it 15 years later?
Because the issues, when we're going back to collateral estoppel, which is primarily what Judge West relied on, the issues are not the same. What Judge West respectfully should be looking at are the elements of a nuisance claim, which is there a harm to the use and enjoyment of the property? And you're looking at the Torsi's specific use, not
All the predecessor in title could have contested all of these things and chose not to, right?
well, he did appeal the
Initially.
the administrative form decision, which is still under the lens of NAREPA. I'm looking at it, just because he didn't choose to file the circuit court case for a nuisance claim does not now bar my client 20 years later from filing a nuisance claim when the bridge was actually built. If we were sitting here arguing about riparian rights, I would agree collateral estoppel applies to that. If we're arguing about navigability under Part 325 of NAREPA, I would agree that collateral estoppel applies to that. That's not what's in front of the court. What we're looking at is the nuisance claim, which is the Torsi's specific use, why they bought the property, how they used it, and that harm and that enjoyment that's been taken away from them through the bridge. And even though I believe the bridge should be enjoined and should come down, even if this court says, no, we're not going to do that, that doesn't do away with the Torsi's claim for the diminution in property value caused by the bridge. This property has canal access and south channel, both. And the purpose for the canals, which we haven't talked about yet, is there is a dedicated easement in the plat, which is the only document on record with Clay Township. I FOIA'd those documents, and the plat itself dedicates the channels, the artificial channels, says it's the canal, to the lot owner. It says the property lines extend to the canal. So they have an easement, which Eagle even recognized. And when they denied a different permit, they recognized that there is an easement in this canal system that they have. So that's the issue before the circuit court, is the obstruction of
What part of the canal?
the entire canal system's an easement.
Right. But where does the property line end for the lot owners on that rectangular piece of land?
Your Honor, if you look at the plat, which I did bring copies of, it's attached to the brief. It's a blue exhibit here. You can see on my.
Here's our blue, ours are black and white. We're trying to keep a budget and
I do have,
use
I
colored
did bring
printers.
copies if you. would like.
No,
Okay.
I've seen it in color as well.
You'll see lot 43 extends halfway into the canal system, which is the actual boundary lines. And then the deed also has a bottom land conveyance, which is behind my client's property, which is a fee simple interest in the bottom land, which has now been obstructed by the bridge. So you have the easement right that's been obstructed, the bottom land right that's been obstructed, the use and enjoyment of the canal system that's been foreclosed, and you also have the $229,000 diminution of value. The administrative law judge and the administrative forum cannot look at any of those issues. Those issues can only be litigated in the circuit court through the nuisance claim. And that's why collateral estoppel does not apply. And that's why the permit specifically reserves the right to pursue and protect the private property rights on the face of the permit.
Why doesn't res judicata apply?
Because for that, the nuisance claim would have had to actually have been litigated and adjudicated.
Isn't it was or could have been?
But
Isn't that the standard?
I think as soon as it probably shouldn't have been litigated.
so res judicata, the three elements are: the prior action was decided on the merits. Both actions involve the same parties or their privies. And the matter in the second case was or could have been resolved in the first. And it could not have been resolved in the first because the administrative law judge cannot hear a nuisance claim. It doesn't have jurisdiction.
Right, but you agree that your client's predecessors in interest could have walked down to the St. Clair County, or I think that's the county we're in,
Right.
circuit court, and said, "Hey, I got a nuisance claim. These guys they're doing me wrong."
They could have, but Hobig never built the bridge. So they never filed
They
it.
put the pilings in.
But that didn't obstruct the access. You could still fit the boats between that. It's the top of the bridge, which we provided photos of this court, that stops the center councils and the cruisers from getting through there. In your honor, even if they had built the bridge, just because they didn't file it, wouldn't still preclude my client from filing that
What's the statute of limitations, if any?
On a nuisance claim would be 3 years.
When did your clients become aware of the problem?
In 2017, they purchased the property. Mr. Hobig started building the bridge in 2023 with no permit. The permit was expired. So then we submitted a notice to Eagle that he was building the bridge without a permit. Eagle issued a stop work order, which he still continued to build it anyway. And then he got an after the fact permit. But the nuisance claim ripened when he started building that bridge without the permit.
When did you file suit?
We filed in, I don't have that date, Judge, but I can,
What year was it? You know what year it was?
uh,
One of your colleagues is here. Do you want to phone a friend?
23. 23, which is when
All right,
it started.
thank you.
building. I think through the questions, we actually covered the majority of my argument. We are asking the court to reverse and remand this.
Oh, you want reversal? I didn't know that. Oh, sorry. I'm
And
just kidding.
remand. The last point I would have is I did also appeal the judge's decision to deny my motion for leave to amend the complaint on the promissory estoppel issue. So we are asking for a reversal on that as well. Thank you.
Morning, Your Honors. May it please the court, Alan Francis for the Hobigs. You got that one right too. So you're 2 for 2 on this
For
one.
two.
Holy cow.
It's on Harson's Island. That's incredible to get 2 for 2. I'm going to I'll rely on my brief. I just want to focus my discussion on some of the questions that were raised and some of the things that haven't been talked about. The Torzies purchased their property in January of 2017. The pilings were in. That's in the record. Mr. Torzie testified he saw the pilings actually when he was out on his boat looking at the property before. But more
Yeah, well,
importantly,
so what?
Yep.
There's no bridge.
there's no bridge, correct. But February of 2017, no bridge. Mr. Torzie sends a letter to Eagle. I know there's going to be a bridge, but I'm asking if you can move it on my property. Not because it's going to interfere with navigation, not for anything, but because I want to use it too. So there wasn't any claim to Eagle in 2017 when Mr. Torzie wrote that letter, nothing. So he was fully aware of the bridge, fully aware it wasn't going to be retractable. He just wanted it so that he could use it. And that didn't pan out. What I want to talk a little bit about res judicata and collateral estoppel, because I think those are the primary issues in this case. And I think they're both in play. Number one of the claims in this case is that the bridge violates the public trust doctrine. I think it was count 2. I may be wrong on my count numbers, but that was one of the claims. That was absolutely decided by the DEQ or by Eagle. In fact, MCL 324-32502 under NAREPA talks about what terminations have to be made in order for a permit to be granted. And it's specifically referenced in the final order in this case from DEQ. And that says that the permit will protect private or public use of waterways over patented and unpatented lands. And whenever is determined by the department that the private or public use of those lands and waters will not substantially affect the public use of those lands and waters for hunting, fishing, swimming, pleasure boating, or navigation, or that the public trust in the state will not be impaired by those agreements for use, sales, lease, or other disposition. That was what was before the DEQ when they made the decision. So the public trust claim, in my opinion, is res judicata. Now, when we get to collateral estoppel, I agree. The DEQ, the Eagle did not decide there wasn't a nuisance. But what Eagle decided was the exact elements that the Torzies are claiming are a nuisance, interfering with navigation, interfering with their ability to access the South Channel. Those were decided by the DEQ. So he can't make a prima facie case of nuisance because we have issue preclusion with the issues that he needs to. And so when that became clear on the motions for summary, we started getting a bit of a moving target. We started getting, well, it's a retractable bridge that was supposed to be built. Well, there's all these other issues. But Judge West properly decided the claim you have in this case requires the court to decide that this bridge negatively impacts and impairs navigability and pleasure boating. Those are the substance of the claims. And he can't make that argument without violating the rules of collateral estoppel. Also, on the nuisance claim, he has to allege and prove an intentional and unreasonable act. And you've got someone building a bridge with permits and with after the fact permits after a contested case with the predecessor and interest. How you can argue those actions are unreasonable, which is a requirement for him to establish nuisance, I don't know how you get there.
How's that not a factual question?
Well, maybe that issue is a factual question, but the prima facie elements are not. I don't think he can get there. You cannot get to his nuisance claim without a different ruling than what was been determined by the.
But
the DEQ.
if you believe that there was an agreement to build this retractable bridge,
Okay.
and you got all these facts floating in the canal, about 50 feet from the South Channel, why didn't the trial judge have a responsibility to simply deny the motions for SD? Let's try this case. It's a 3-day, maybe 5-day case.
I'm glad you brought that up because we're talking
glad
about
you're
two
glad,
different
so.
issues, and I was happy to talk about it. Because the retractable bridge argument is not part of the nuisance claim at all. It's part of a request
the amended.
to leave for a
Right.
promissory estoppel claim. And Judge West, that's an abuse of discretion standard. The evidence they presented in favor of the retractable bridge promissory estoppel wasn't that my client promised to build it. It was Mr. Torzi's testimony that he promised not to object if my client built it. So Judge West said that is not a definite and specific promise by my client, Mr. Hobig, to build a retractable bridge. That's your promise not to object if he did. So it wasn't part of the nuisance claim. We're looking at an abuse of discretion standard, whether it was futile to amend, and it was because there was not a definite and firm promise. None was alleged. That was the testimony.
Even taking whatever averment is made by opposing counsel's clients about what was promised or agreed to, and that they had some boat party and somebody tied their boat up to his property and that made him mad, and that's why he withdrew the permission to use it. That it does the judge, in making the assessment of whether or not to allow to amend, does the judge have to take the facts and the reasonable inferences therefrom in the light most favorable to the party seeking to amend? And if the judge does have to do that, wasn't there enough evidence to require the court in operating and doing its due diligence? And I mean, I can't speak for Judge O'Brien as a former circuit judge, but I know the waterfront property cases are always very hotly contested, and that's great. I mean, I understand it, but didn't the judge should the judge have just said, okay, I'm going to let you amend. Let's go. Let's get this thing tried.
If we're still talking about the retractable bridge, absolutely not, because he still has to establish that there is a prima facie case. And again, the testimony, because we were complete with discovery on this. So I had deposed Mr. Torzi, and his testimony was not that my client promised, which is what you would have to establish, a definite and clear promise by my client to build the retractable bridge. And the promise, his own client's testimony, the promise was that he would not object, not that my client would build it. So you still have to have something. You don't get your day in court just because I allege a promissory estoppel unless there's something behind it. And in this case, it wasn't even he said, she said. It was his own testimony. And also
at some point before you sit down, I want to hear from you, and I'm going to want to hear from brother counsel. Is the issue of necessity at all relevant in this case and the law applying in this case?
I'll come back before I
Yep,
forget this
that's-
idea. The other issue on the promissory estoppel, I think Judge West was correct on, was this was testimony and alleged promise not to object that occurred prior to the lawsuit. And this request to add the promissory estoppel claim doesn't come until after our hearing on motion for summary disposition. And Judge West properly found there is no reason for this delay. This promise was made years before this lawsuit occurred. And we're essentially moving the goalpost. On necessity, that issue was actually resolved in favor of my client by Eagle. There was this allegation that a footbridge or some other bridge in a different location would work. And the decision specifically found that there was not a reasonable alternative.
Interesting answer. And I appreciate that. I remember that from the record. But what I'm talking about is the necessity of the plaintiff to have riparian access. If they have, if their lot, if the lot is, shaped like a rectangle, like the legal pad I'm holding, canals in front, the south channels on the other side. If they can build a dock on the south channel, does that impact in any way the decisions that the court has to make, this court and the trial court, on the bridge staying or going or being put in the first place, or whether it's a nuisance?
It came that fact, and I appreciate Mr. McKenzie acknowledging that his client could build a bridge on the South Channel because it's true.
Not a bridge.
Yeah,
Well,
or
that,
pardon me,
I
thank
think
you. Pardon, a bridge would
you'd
be
have to
something
talk
else.
to Canada about that.
That'd be a little bit more. Build a hoist or a dock on the South Channel, because that wasn't testimony. It's true, but I don't necessarily. And the judge referenced it. It probably, I don't recall.
Is it of any moment to us?
I don't believe so.
Okay.
I mean, I believe if we go back, it may be relevant to damages, but I don't believe it's relevant to the basis for the dismissal in this lawsuit, which was collateral estoppel.
Thank you.
And one thing I wanted to point out too on this issue of the size of the boat, and I'm going to read from the proposal for decision in the DEQ case from 2005 or 8 or whenever this decision came out, because it talks about the things that Mr. Torzi's predecessor was arguing. And this is a quote. In particular, petitioner, Mr. Torzi's predecessor, claims he will not be able to pass under the bridge in his recently purchased 24-foot pontoon boat, which requires 9 foot of vertical clearance.
Right, and the court said, yes, you can, because if you lower the canopy, you can get
Yeah.
underneath it, but that's not how these plaintiffs used that.
Correct.
They were actually using bigger.
But I think the argument then becomes, hypothetically, had this bridge been built in 2009, immediately after this permit.
Right, so what you're getting is these people come in, but this decision was made under the use of a pontoon boat, whereas these plaintiffs are bringing in big boats through here. And now all of a sudden it goes back and now it's retroactive to them.
Well, the last sentence of the paragraph I was reading, he also has a long-range plan to buy a sailboat. So that issue of I might have a different boat someday was addressed in part of the DEQ decision.
Right. Yeah.
And
Go ahead.
You could have a retractable keel. You could have a retractable mast. I mean, go to the Chesapeake Bay if you want to see sailboats that can get under a bridge with a 9-foot clearance. So your clients did not build that which they had permission to. The new property owners come in. There's no bridge there. They're center console people and they like their center console thing, or maybe they have a flying bridge because they like to fish and they want to be able to spot you whatever out on the waterway, and they're able to use it back and forth, and then you're now I'm going to do it. Well, come on, how is he not kept from doing that?
because the DEQ in the record here, this bridge that my client built, and again, it's important. The dimensions of the bridge are the exact same that were approved in 2000. There's
But
nothing.
he did not build it, and the permits had expired, as counsel said.
And he got an after the fact permit, which was also challenged and affirmed. So the question is, how is him building a bridge that was permitted? And I understand this distinction of when the permit lapsed and didn't, but how is that unreasonable? And that's what he has to prove. And he has to prove that it negatively impacts navigation. The DEQ's decision talks about all the bridges on all the canals on Harson's Island, and
Right.
how this is highest, and we allow them, it's 2 feet higher than the average bridge or 2 feet higher than the tallest bridge, and how those bridges over those canals don't negatively impact navigation. And the reason is primarily probably because you have cell channel access on this one. But that's a decision. He has to get that specific language, that determination. It doesn't matter if the bridge was built in 2008 or not. We have a determination that the bridge was built, the bridge that was built will not negatively impact navigation. That's the determination we have. It wasn't that it won't negatively impact navigation in 20 years, or if it's built in 2 years, it's that it will not. That's the decision. And that was a reversal. So this has been looked at now by the DEQ administrator who overturned the proposal for decision and affirmed by the circuit court in St. Clair County. It wasn't limited in time. This wasn't a situation where, you know, had Mr. Torzi's predecessor, Incher, actually bought a flybridge boat, and I pardon my language, I'm not a fisherman, but I think I was close to what you referred.
Flying bridges are a beautiful thing. You get
But
to see the fishies a long ways off. So
It wasn't a situation where there's no reference in the decisions where, well, had you had a bill of sale for a different size boat, we would have decided differently. What they did was said, look at all these bridges and they don't impact negatively pleasure boating and navigation. That was an exact statutory requirement that the court, or pardon me, that the DEQ had to make, that was affirmed by the circuit court. It's not limited by time. It's not limited by person. It's limited by the type of bridge that was built, and we have the same bridge that was built here. So you don't get to relitigate the issue because the bridge wasn't built within the permit. That does not change the DEQ's rule. In fact, they had a second opportunity and the after the fact permit to challenge it. And we're still here talking about how an after the fact permit was granted. So they've had several opportunities to challenge this decision that it negatively impacts navigation. We have an affirmed decision by the Court of Appeal, by the Circuit Court in St. Clair County from 2008, confirming that it doesn't.
Well, they just have an easement that they can't use.
Oh, they can use it. Maybe not with their preferred boat, but they have an easement and there's a bridge and there's a determination that bridge does not negatively impact navigation. I don't know how we get around that. Regardless.
So is there 9 foot of clearance from water, average high water level to the crest underneath crest of the bridge?
I have not measured. That's my understanding. The bridge was built as it was originally permitted in 2008. And I would look at it this way. If we had a nuisance case in 2009, let's say the DEQ doesn't exist and my client wants to build a bridge and Mr. McKenzie's client runs to the court ahead of time before the bridge is built and says, no, if you build this bridge, it's going to negatively impact my navigation route. Okay. And you have a court ruling that says, no, it's not. But the bridge doesn't get built for 20 years. There's been no change in circumstances that would render that court's decision somehow temporarily limited by when the bridge is actually built. And so we have that determination. We have the decision. It's not limited by time. Anything else? This is my third Parsons Island case, maybe in a year. So
What, we got that feeling from what the trial judge said about Parsons.
That sounds like the trial judge has had a few Harson Island cases too.
oh, he's more familiar with boats than myself. Unless there's any questions, I'll rest on my brief.
I don't see any.
Thank you.
Your Honor, I just have a few quick points on rebuttal. First, I'll touch on the retractable bridge because I didn't touch on that in detail.
Sorry,
The promissory stopple retractable bridge issue. Yes, we addressed this. There were pilings in the water when my client moved there, and he had that discussion with his neighbor, and they agreed that he would build a retractable bridge, and my client would not object to that. That was the agreement, and he actually started performing that agreement. He cut the pilings to do the retractable bridge, and then when this disagreement occurred on 4th of July, he stopped and said no, and then he actually welded pilings back on top of each other to do a stationary bridge. So I do believe that there was enough for under the liberal standard of leave to amend that was filed before the MSD hearings, and there was an abuse of discretion to deny that under futility because it was not futile. Secondly, Brother counsel is doing a good job of driving this court down the same path that he drove Judge West to confuse the issues. I mean that respectfully, not disrespectfully. What I'm saying is what the administrative law judge looked at in the administrative forum, those issues are not and cannot be the same because of the jurisdiction. And whether
So
navigability was.
what relief are you seeking? What do you, in your perfect world, what does the opinion from this court look like? Period.
From this court, we would be looking for an opinion that reverses because all Judge West ruled primarily is that collateral estoppel issue preclusion, that it was navigability was decided. We would be seeking reversal on the nuisance count. The nuisance count is the only claim I'm seeking reversal on, none of the other counts in the complaint. And that leave to amend be granted on the promissory estoppel.
So you want to be able to try the nuisance and you want to be able to make your averment on the promissory estoppel.
Yes.
And that's it.
Correct, because the statute, if I'm successful, the statute allows for abatement of the nuisance, which would be taking the bridge down. But the law, even, and if I lose on that issue at trial, the nuisance law still allows my client to seek damages for the diminution of value to the property that they've now suffered, which was supported
if
by
any.
appraisals. And well, the $500,000 that they're going to have to spend to build docks off of.
Right.
the South Channel.
If the fact finder doesn't find that they were completely on notice of this and it's totally, they walked into the hazard and it's their
Coming to
issue.
the nuisance, yep,
Yeah.
I understand that. That's a factual issue that we would deal with at trial. Right now, we're just asking, all that's before the court is a collateral estoppel issue, really, on a nuisance claim.
Is a nuisance, and I don't know, do you warrant a jury trial, a jury on a nuisance?
Yes,
It's an equitable remedy?
well, I think so.
I don't know. Thank you.
Thank you, Your Honor. Your Honors.
Thank you both. This matter is submitted. Our next case is item number 6, docket number 374594, Thomas McWilliams versus Tri-County Bank. You may proceed.
Good morning, David Hybo on behalf of the appellant, and we do not have any fly bridges involved in this case. I did have one. though, and
It's
I
an
did-
interesting case.
I'm sorry?
It's a very interesting case, as is this one.
Yeah.
I'll pick up where they dropped off about discussing promissory estoppel, because that is not what this case is about. I guess I would maybe like to talk about it, but the legislature has sounded the death knell to that type of case. We have a situation, and I understand that my client can be criticized for not perhaps being more involved or taking action, and I'm not going to call him a farmer who's kicking the sod, waiting, because that's what my grandfather was back up in Port Austin back in the day. But the fact of the matter is, and I also understand that Tri-County Bank, even though there's a creditor-debtor relationship, does not have a fiduciary relationship based upon the case law, and I get all of that. However, when you get to the issue of duty, I think Michigan law is very clear that when you undertake an act, you have now created a duty. And that's why I tell my wife continuously, when I stop my car and let somebody have space, I'm not waving them in. If they don't know what to do, that's their problem. I am not going to wave somebody forward and create my own duty. I grew up, I may be up living in Port Huron, but I grew up in the northwest side of Detroit. So I'll leave the space,
too.
but I'm not going to tell them what to do. And I think that's one of the key cases, because we have a situation here where once you undertake a duty, and you've assumed to act, you have voluntarily undertaken a duty. My client would walk into the bank, he would make a payment, or he would ask what's going on with the loan. I'll get back to you. I'll get back to you. I'll get back to you. That went on for over 9 months. And one of the problems, and that's not even what this case is about, is that when the loan was finally rewritten, the interest was retroactively adjusted. But that's not even what this is about. This is about, am I going to get any new money to be able to put a crop in the ground? And he is not told until late June that he was not going to get money.
Right.
Late June is too late. The bank knows that. They are banking, they're agricultural experts. Judge Rathel, obviously this is a C8 motion, so we have no discovery. And Judge Rathel found that under no circumstances can there be a duty. And he cited the Ulrich case, but the Ulrich case, that claim of negligence in the Ulrich case was that they negligently loaned money to somebody. And here we have Michigan case law, which clearly indicates that when these matters are presented to an individual such as the bank, they have a duty to respond fully, fairly, and accurately. And they never did. Now, I understand Judge Rathel made a comment about, well, what's a reasonable period of time? I understand that. And to me, those are more factual issues, because I'm not going to say that this case may not have segments of comparative negligence on my client's part. But I think when you walk in, if they wanted to say, we're not dealing with you, say it. Whatever the bank never gave a reason. They simply said, I'll get back to you. I'll get back to you. I'll get back to you. And that was repeatedly. We don't even, obviously in this case, we don't even have them denying that fact because it's a C8 motion. They simply said that what we have alleged, that when our customer comes in and asks about money, operating expenses for the next year's inputs, we can string them along, not deny it, just string them along. I'll get back to you. We have no duty. We have undertaken no duty. And I think when you said, I'll get back to you, you've undertaken a duty. You have an obligation. You have voluntarily acted. You have assumed that you have assumed the obligation to get back to the person. And now you have to fully, fairly, and adequately respond. And I don't want to make it sound much more simpler. And I hate to put it in those terms, but I think that with all due respect to Judge Rathel, he missed the boat on what the negligence claim is, because case law clearly recognizes that with a bank, you do not have a collateral estoppel. With a bank, you do not have a promissory estoppel claim unless the act is in writing, which it isn't, but you still can have a negligence claim if it's from a separate obligation. And here, I believe we clearly have alleged a separate obligation. We're not coming in claiming you didn't rewrite our existing loans, which had termed out. We're claiming we're asking you for more money. We're asking you, what are we going to do? You took on the obligation by saying, I'll get back to you. This is a small town issue. My client would walk in to make a payment. He would have conversations. This is what we've alleged. And I believe when they've undertaken that obligation, that is a duty. And because Judge Rathel simply found that there is no duty. Obviously, when they've undertaken that relationship, they've created a legal obligation, and therefore this matter should not have been dismissed under a C8. I'm not going to say that at some point it may not have been dismissed under a C10. I'm not going to give that because we just haven't gotten there. But from a C8, the Court of Appeals has mentioned on at least 2 occasions that there can still be a negligence case in these lending situations. In fact, Ulrich itself acknowledges you can have negligence. It simply was that case the action wasn't negligence. Thank you very much.
Morning, Your Honors. Hayden Peterson on behalf of the appellee, Tri-County Bank. May it please the court. The circuit court should be affirmed for 3 reasons. First, the bank did not owe Mr. McWilliams a duty to respond to his request for a loan. Because there's no duty, both claims fail. Second, specifically as to the silent fraud claim, the circuit court determined that Mr. McWilliams, that his reliance on the bank's silence was unreasonable as a matter of law. And Mr. McWilliams has not challenged that on appeal, so it's forfeited. And even on the merits of that issue, the trial court was correct. And then finally, amendment would be futile because Mr. McWilliams has not offered and cannot offer any additional allegations that would state a valid claim. So to the first point about duty, trial court correctly ruled that under Michigan law, the bank did not owe Mr. McWilliams a duty to respond. Ulrich is a case that's on point. The bank, or the court held there that the bank, here's a quote, had no independent legal duty to exercise reasonable care in determining plaintiff's eligibility for a loan, end quote. Appellant thinks that that's distinguishable because it's concerning the determination of eligibility, but in order to get back to someone about their eligibility for a loan, the bank first has to determine whether they're eligible. So I think that Ulrich actually does more than what's necessary here to establish the principle that the bank doesn't have an independent duty. Banks have all sorts of duties. Banks have contractual duties. Banks have duties under various regulations. But here, as appellant concedes, there's no fiduciary relationship between the bank and Mr. McWilliams. As to the silent fraud claim, I think the concession that there's no fiduciary relationship kind of puts that claim to rest. And as to the negligence claim, there's just no special sort of relationship. This is the bank is determining whether it's going to make a loan. It's determining its things about its own interest. It's not acting as Mr. McWilliams' agent. It's not, there's not any sort of special position of trust here. It's a commercial transaction. And to say otherwise would be to open the bank up to all sorts of tort liability whenever a customer isn't satisfied with the bank's method of communication. But the law doesn't impose standards on customer service. I'll move on. Unless there are questions on that, but I'll move on just quickly to the second point. Mr. McWilliams' reliance was unreasonable. The court determined that. He has not appealed that. That's an independent reason to affirm the silent fraud claim. On the merits of that point, the Michigan Supreme Court has held in Curry, which is cited in the brief, that, quote, general discussions of extending credit should not lead a borrower to reasonably believe the credit will be extended, end quote. So that's the case here. Mr. McWilliams his reliance was unreasonable because these were just general discussions. And then finally, any amendment would be futile. The trial court was correct about that. Appellant hasn't identified on appeal, and he didn't identify below anything that he could allege that would cure the defects in his complaint. And we don't believe that he could, because the question of duty is a matter of law, and no duty exists. So unless the court has any questions, because the trial court did not err, the decision should be affirmed.
No questions.
Is this your first argument?
It is.
Oh, wow.
Okay,
Holy cow.
very nice.
Well, you brought the grizzled old veteran with you, so.
Thanks.
No, it's good to see you, Miss.
Good to see you, Mr. Nelson.
I think anytime you get to be co-chair of the Michigan Appellate Bench Bar Conference, I think you get to be called a grizzled old veteran with all great appreciation for your help. But anyway, you didn't get there by having this be your first rodeo. So
Briefly.
Yes, you have rebuttal. You have plenty of time.
Council, we never relied on Curry because Curry is a promissory estoppel case. So we've never relied on that because obviously the legislature took care of that. So we rely simply on the duty that the bank accepted. They voluntarily accepted the duty. And from that standpoint, the case becomes a negligence action, not a contract action, and not a promissory estoppel action. Thank you.
great.
Thank you. Thank you. That matter is submitted.
It's up to you. I'm fine going.
Like, yeah. Before we begin our 11 o'clock, we're going to take a short break.
State of Michigan is now second.
All right. Ready for the 11 o'clock call. We're calling item number 7, docket number 370757. Patrick Wolick versus Corwell Health. Mr. Kamenek.
Good morning, Your Honors.
Good
Is
morning.
it morning? We just,
It is.
It's
just made-
just
We just
barely.
squeezed you in.
thank you. And I won't be done before noon, I'll tell you that.
Well, come on.
Come on, give it the college, old college try, Mr. Kamenek. We know you can do it.
This, if I can start off with procedure, and I don't care how we do it, I know we're the principal appellant,
Uh-huh.
and I don't, but I know also there's a J&OB issue, so I don't know how you'd like us to address things. If I can get some guidance from the court, I can address that issue, but it doesn't make a lot of sense for me to address it before Ms. Beach does. I also, if it's the court's druthers, I also talked to Ms. Beach ahead of time, and on our respective issues, if the court is willing, we would like rebuttal. So with all that procedural mess, I'll be quiet.
All right, so you want to just do your appeal and then have her respond to you and then do rebuttal and then have her do her cross appeal?
I guess we could do it that way. Again, I don't know how.
Well, you're gonna have a running clock. It
Yep.
ain't gonna go past
So-
30 minutes.
I agree on
So,
that.
yeah.
So, well, okay.
Well, why don't you just dive right in
Why don't I just
and
dive right in?
I'll tell you what, why don't we leave you 10, we'll cut it in half and we'll try and do it in
Okay,
15.
and one way or the other, I'll reserve 5 minutes for rebuttal, so now your math is off a little bit. I waited till you said it before I did it.
Oh, good.
You know,
So
that's not even
12:30.
law, because
Yeah.
I'm not good at math, but
Well,
okay.
I'm an English major, so.
All
again,
right,
if-
I'll try.
Thank
I'll
you.
try my
Remove
best. So
this.
I'll say 10 minutes
Okay.
and then we'll have my
Well, I'll
speech.
try to address what I can and let's
Okay,
go
go ahead.
backwards. I know the court's prepared. I've
Go ahead.
been up here enough times. So may it please the court, Rob Kamenak, I represent the plaintiffs. 5 minutes for rebuttal. There are various issues on appeal and cross appeal. The cross appeal issue, I guess I can go ahead and just address it and make this.
Oh, well, then,
There's so much for
okay,
that.
so much for that.
Okay.
And there's 3 issues. On the cross appeal, let me set the stage. The court knows about the case. I won't go through the facts. If you have questions on the medicine, please ask me. But otherwise, I'm assuming you know the medicine enough to go ahead and resolve the issues. If not, I can tell you a little bit more about the case. But this case deals, it's a med mal case.
Mhm.
It was tried in front of Judge Mattis up in Oakland County.
Right?
15 days. It was the classic battle of the experts, which you often have in medical malpractice cases. The judge had 8 jurors sit, and all 8 jurors came back with a unanimous verdict in favor of the plaintiffs. And that is both on the principal claim for the plaintiff and also the loss of consortium claim for Ann Willick. So again, I'm just going to go straight into the JNOV. The defendants are arguing that they're entitled to JNOV. Medical malpractice cases are not well suited for JNOV type motions or against the great weight for the reason that I just told you, because it is the battle of the experts. When you have expert opinions that clash, which you did in this case, it's the jury's job to address the credibility and the weight. And that's what we've got going on here. And that way I think we restrict the judicial intervention, if I may say respectfully, to respecting the role of the jury. So in short order, I understand there's 2 basic factual arguments on the JNOV. And the first one is that there wasn't enough symptomology to even do a test for AEF. And there's all kinds of testimony to the contrary on that. But I don't think you have to go beyond Dr. Muscat's testimony. He said, so based on the history of the plaintiff as presented, you don't wait. You go ahead and do the test. That's in the appendix 809A. That standing alone is enough. Okay, the second argument is that if you had done the test, you would not have found the AEF. And that our expert, Dr. Muscat, destroyed that because he testified directly based on the medical records and also based on the testimony of the other physicians that there was a 98% chance that a chest CT would have revealed sufficient evidence of an AEF. Okay. So you don't really need to go beyond that. On rebuttal, if you have questions beyond our experts' testimony, I'd be happy to address those. But I really don't think we have to go too far on that, if I may. Now, there is an argument to be made, I think, by the defendant that somehow Dr. Muscat should not have testified and that his testimony should have been stricken. And that is the basis in part for a directed verdict motion that was made. You know from the briefing that there was a request to strike the doctor's testimony through a pretrial order. It was withdrawn. We call those Daubert motions. I'm sure you've heard that term before, or Daubert, take your pick. I'm from Michigan, so I'd use Daubert. And it was never refiled. So usually in a medical malpractice case, if you're going to go ahead and try to say the other expert's not qualified or the methods or the principles aren't reliable, you file a Daubert motion. Wasn't done here. Now, the directed verdict motion does not substitute for a Daubert motion. Under Michigan law, if you have a debate on MRE 702 and it involves scientific principles, then you have to have a hearing. So it wasn't as if after all the briefs, Judge Mattis was going to stop, tell the jury to go get a cup of coffee and have a hearing. That wasn't going to happen. So I think that with the JNOB issue, the court should simply affirm Judge Mattis. He was on the ground. He heard all the testimony. He understands it and he denied it. He had a very good opinion, which I think is noteworthy. One other point on that, and then I'll move on to the other issues. There was an article that all the experts were referring to, and if you went through the transcript, you kept seeing the 98% number. And it was an article called Arterioesophageal Fistula. And Judge Mattis quoted this article when he denied the JNOB. And he said, and it reads, clinicians should have a high suspicion for the development of AEF in patients presenting with infective, neurological, gastrointestinal, or cardiac symptoms within 2 months of the atrial fibrillation ablation. We have the classic case here. It was after 21 days after the ablation that you had this AEF develop. You also had Dr. Wong, who had done the ablation, who had 2 other patients in the prior history who had this condition. So he was very concerned about Mr. Wallach. So the day after the ablation, he went ahead and he did a scope and down the esophagus, and guess what he found? He found burns, which leads even more to the notion that the condition existed and the condition would have been found. So, and the principal appeal, that's all I'm going to address. Now, let me talk about the past medical expenses, and then I'll talk about very quickly case evaluation sanctions. Past medical expenses, there was a stipulation made on the record, and the court is likely familiar with it. It's very short. I thought I would read it because it's part of my argument. And by the way, the stipulation was run by Judge Mattis first early in the transcript and then read verbatim here. The parties stipulate that the amount of medical bills for the medical care and treatment of the stroke suffered by Patrick Willock amounted to $313,541.
And
These
0
charges,
cents.
I'm sorry.
And 0 cents.
I'm sorry, you're right. Mea culpa. These charges do not include medical bills for the care and treatment of Mr. Willock's AEF. So Judge Mattis found that since in his view, there was not an agreement between the parties to actually put that number on the verdict form, but the stipulation wasn't enforceable. And he made a mistake. What else?
I don't think the judge made a mistake here. I think the attorneys made a mistake. You can't blame the judge. The judge asked several times, are you sure this is all that you want to be read to the jury?
Yes.
So there should have been more of an explanation agreed upon by the attorneys that was read to the jury so they knew what to do with it. And further than that, plaintiff's counsel during his closing should have explained to the jury, here's a stipulation, here's how you handle it. You include this number in your verdict. So and the verdict form was agreed to also, which was another problem. The verdict, and one question I have for you is, what relief can we give you on that issue? How do you see us giving you relief?
Well,
What would that look like?
I'm sorry, Your Honor. We filed a motion to amend the judgment to add it back in. The other thing we filed alternatively is that we would want, if the court really feels like there's some dispute on this, then we want a new trial on past medical expenses only.
Well, what about, how could we do that when the verdict form did not break down what was for medical and what was for the other past economic damages? There's no breakdown. So how?
I'm sorry, Your Honor.
So how would we do that? Wouldn't be fair because maybe the jury did consider the medical. We don't know that.
Maybe the gross number includes it.
Includes it.
But since there wasn't a delineation asked for, how are we supposed to divine that process.
I understand what the court sees as a dilemma. I really do. But the fact of the matter is the jury had no role in this. Once a stipulation was made, it by operation of law, it was going to be added to the verdict. And if,
That wasn't clear at all.
well,
That
but
was not made clear.
Teva says that. The case law that we rely on says it.
I
It
don't
says,
agree.
it says that it's necessary, if I may, and we may disagree on this, and I understand. But I don't read Tevis. I read Tevis to read that, in that case, the question was whether there was a triggering event. And the court found that, and I quote, the jury's determination that plaintiff was not the owner of the motorcycle and thus entitled to PIP benefits, italics necessarily led to the entry of a judgment incorporating the stipulated damages. That's exactly what Tevis says. And so here you just equate it. The minute the jury found that there was in this particular,
We're trying to extrapolate from a statutory benefit of PIP, which is highly regulated, highly administered, highly statutorily controlled. We're trying to take that principle, and I'm not suggesting that it's incorrectly decided, but take that principle into it. Here's a stipulation. This is what the cost was. And nobody tells the jury by stipulation, this is an element of damages that if you find liability, you should include this, or you must include this, or you should consider it. And again, like Judge O'Brien said, so we go back and try it just on this? How do you do that?
well, it would be a 1 hour trial because you already have a stipulation on the amount and also that the amount reflects the damages for the injury.
But counsel, because you didn't ask what the specified elements of the previous economic damages were, how do we know, and how does the defense not have the right to introduce all this other stuff, including the amount of the gross verdict that was entered for previous damages, including the claims? It seems so, and I know you don't not reverse because it's going to be hard. We're in the business of doing hard stuff, but
So am I, Your Honor.
yes, I have some vague memory of that
There
back
we
in the
go.
90s.
As I'm doing something difficult right now, and I understand that. I understand the dilemma. And insofar as the court is saying, how do we unwind this? Because the jury might have considered it. I don't have the best answer for that.
Okay.
I really don't. We thought about it. We do know that there was a lot relied upon by the respective attorneys here. That the stipulation would just be, in my view, and I know the court may disagree, would just be added to the verdict or the judgment, and that didn't happen. Now, the reasons that you are citing, and I acknowledge the court can go down this road, they're not the reasons cited by Judge Mattis. He didn't bring this up. So I'll say that much. And
Well, he kept saying you agreed to this. This is how you agreed to present it to the jury. I just did
Right.
what you approved. You
well,
approved the jury instructions, you approved the verdict form.
and he did say that he expected that the stipulation would include a statement that it should be included on the verdict form. I agree with that. That's the way I read his opinion, and also the transcript. So let me move on to the case evaluation sanctions because my time is running. Okay.
I can't believe you don't like red.
I think the author was brilliant on that case.
I don't know if the Chief Justice would agree with you on that
Well,
one,
well.
at least as relates to that case.
And it's funny, Your Honor, because I believe, just 10 seconds, I believe Rad might have been argued here, but I know he had an argument after this and you were going to town on it. So
Apparently
I
not
wasn't-
very well.
I was not going to bring that up. So you brought it up. So what?
No,
can I say?
I told, well, anyway, yes,
All right. So
please.
case
I digress.
evaluation sanctions. The court knows the sequence of events here. You know that everything was done, in my view, under the old rule. And then suddenly, not suddenly, but then you have a trial under the new rule. Judge Mattis found that didn't constitute a basis for awarding, applying the old rule and applying the case evaluation sanctions. I think that logic has been blown out of the water in Webster. Because in Webster, the court did go down that very road and found the notion that there could be reliance on the notion of case evaluation sanctions being awarded. And a matter of fact, when you go through Webster and you line up the facts of Webster with the facts of this case, it's amazing how close they are. In Webster and in this case, almost everything happened under the old rule. And that included the multiple motions to adjourn trial to push it. I'm not saying it was necessarily nefarious, but to push it over past the effective date of the new rule. That happened in Webster. The settlement negotiations happened under the old rule. Obviously, the case evaluation happened in the old rule. And of course, Webster is decided differently. Now, I understand that was Judge Biernat over in Macomb County that had that case. I understand that there's still an abuse of discretion standard. So what happened necessarily in Webster doesn't happen here. I got that. But what I think is more important is I don't think because he made the decision prior to Webster that Judge Mattis went through and properly evaluated all the elements. And we know he went through the timing. I don't see anything in his opinion talking about the purpose of the rule. That was one of the factors in Webster. And obviously the court knows the purpose of the rule. We've lived with it for eons. The purpose of the rule was to motivate settlement. And also candidly to assess a penalty to do so. And that would have applied here. You have two affidavits of record, one by Mr. Matusas in the courtroom and also by Patrick Wollock, explaining all the settlement negotiation was done under the auspices of the old rule. This case didn't settle. We're in the 8th year of this case. And here we are on appeal, and that's fine. But this case goes on and on and on and on. Okay. And that happens in a
That's
lot
in
of
the
cases.
record today, though. That was.
Yeah, there we go. And maybe I'm going on and on too, but okay. But it goes on and on. And the case under all the settlement negotiations were set because of the old rule. So we have it in the brief. The case of L was 1.25. It was done when in our view, when a piece of a particular medical record was not disclosed, Dr. Grisevich's report, that particular report said that Patrick Willock was permanently and totally disabled. That record mysteriously applied and was produced the day after acceptance or rejection. I don't believe in coincidence, but you can figure out what that is. That's the gamesmanship. And we've all been there. What happens when a plaintiff accepts a case evaluation award in terms of negotiations? The defendant treats it as the ceiling. It always happens this way. It was the ceiling. We were trapped in that particular situation. And because of that, there were no negotiations. The number never went up from 1.25. And instead, we were forced to try the case. Yes, we got a good result. But in Webster, the mere fact that you got a good result doesn't mean that the old rule is inapplicable. So the rest of it, I've got it in a brief. I'll save the rest of my time for rebuttal on all the issues. I tried to address them all. On last point, I guess, always last point. I'm not going to argue the cap. I understand that this court probably feels like that the cap's unconstitutional. Probably feels like it's bound by the Michigan Supreme Court law. I could
Probably.
make sure I could distinguish Phillips, but I won't go down that road. And I know you had et cetera.
Just after been reading cases the last 3 weeks, if you had any question.
I know. So, but I want to make sure for the record that it's preserved. Okay.
Oh, it's preserved.
Okay.
Yes.
All right. Thank you.
You have about 10 minutes, so
Thank you.
He only wanted 5, Judge Latigo.
well, he's got 10. So Ms. Beach.
Valuable the time.
Good afternoon. May it please the court, Karen Beach on behalf of the defense. I appreciate Mr. Kamenek's offer to let me have rebuttal on my cross appeal, but I think I can probably address everything this presentation. So
Okay.
thank you. So, I'm going to start with medical expenses. And I think the court has made its feelings towards the stipulation clear, so I'm not going to talk about what the stipulation said or didn't say. But Judge Letica, or it was maybe Judge O'Brien, you asked what relief can we give the plaintiff?
Judge O'Brien.
Judge O'Brien. And
the plaintiff has been trying to jam the square peg into all shapes of holes. They tried the round hole of amending the judgment, tried the triangle hole of an irregularity in the proceeding, and then on appeal, they're even trying the star-shaped hole of prevailing party misconduct. The only hole that fits the square peg is the square hole, and that square hole is additor. If you're saying that the jury was told this is the amount of past medical expenses, here's where you award past medical expenses, and the jury didn't award past medical expenses, or we don't know if the jury awarded past medical expenses, the only conclusion allowed under the court rule that supports plaintiff's argument that they keep making is that the verdict was inadequate. What happens when the verdict is inadequate? The defense is given a choice between additor and a new trial. And I think we've fairly well briefed why new trials on damages only are disfavored. That would not work in this case. So I think the only relief this court can give plaintiff is additor or a new trial. On the case evaluation sanctions, Judge Redford, this is your chance for post-rad redemption. And I'm going to explain to you.
No. I may have been born at night, but not last night.
I'm going to explain to you why Webster doesn't require the trial court to go back and take another look
I
at
need
this.
no redemption from the learned decisions of our state's highest court.
Understood. So the trial court didn't, the only thing Webster says is that we defer to the trial court's discretion. It doesn't establish a bright line rule. It doesn't.
Wait, when I say I seek no redemption, I don't mean I don't, it means I respect them and I'm going to follow what their orders are. That's, it
Understood.
is recorded. So I don't want there to be some suggestion that I'm trying to be discourteous. I'm trying to be the opposite. I think very highly of all 7 justices. They're great judges.
Sure. So the only thing that Webster says this court has to do is accord due deference to what the trial court did in its determination, if it follows the Reitmeier factors and the MCR 1.102 analysis, which the trial court did. The trial court had RAD, and it said, RAD kind of establishes this bright line rule, but I'm not going to follow it. I'm going to go with Reitmeier. I'm going to go with 1.102. So the trial court did what it was supposed to do in this case. And the fact that the Supreme Court in Webster keeps coming back to this as a highly discretionary analysis, it means that the trial court is not required to reach the same result as Webster, even if the facts are similar. So the Supreme Court certainly could have said, look, we're going to make this easy on you trial courts. If case eval happens before the rule change, we apply the old rule. If case eval happens after the rule change, we apply the new rule. They didn't do that. Instead, they spent lots and lots of pages talking about we have to defer to the trial court as long as the trial court applied Reitmeier. So the trial court therefore was allowed to assign different significance to the fact that trial was adjourned until after the rule change and the reliance standards. And if we don't find that the trial court can make different findings, then there is no abuse of discretion standard. Webster becomes a bright line rule and Webster's not a bright line rule. So under the law and authority available to the trial court here was the ruling an abuse of discretion. It was not. I think the conclusion that on the timing that the plaintiff chose to proceed to trial after the rule change, it's certainly true. You know, they chose to proceed to trial after the rule change. There were 7 figures on the table. They were not forced to try this case or leave empty-handed. They said, we're going to roll the dice knowing that we're insulated from sanctions. And that insulation from sanctions for a plaintiff is the purpose of the new rule. We don't talk about the purpose of the old rule under Reitmeier. We talk about the purpose of the new rule. And the purpose of the new rule is to eliminate the sanctions, to level the playing field between individual plaintiffs and corporate defendants. Now, that purpose of the new rule would have been implicated here if there was a defense verdict, because then you'd be looking at the Wolaks paying for Beaumont's attorney fees. But it's not implicated here. Plaintiffs not being asked to pay our attorney fees. And the other purpose of the new rule is this notion that sanctions are useless in getting parties to settle. Well, yeah, the threat of sanctions did not and has not forced defendant to settle this case. So really, this case plays right into the purpose of the new rule. And it doesn't work a new consequence under Reitmeier. There's a lack of consequences, and that's what Judge Mattis found. And I think that was a reasoned and permissible application of Reitmeyer to the facts of this case. I also want to highlight or talk about the reliance factor. Judge Redford, you had another opinion in PAC versus JJ Development where you found it was significant in applying the new rule that most of the attorney fees occurred after the new rule was enacted, meaning they should not have expected recovery for those fees. PAC was never overruled.
Oh, I didn't get reversed on that?
No,
Okay.
no, that still stands. So I think that's good reasoning that Judge Mattis did apply in reaching his decision in this case. And the reliance is reliance on a contingent event by plaintiff. If you're saying they're relying on the fact that they get case eval sanctions if they win at trial, that's not reliance that took place at the time of the rule change. That's reliance on a contingent event that has yet to occur. The only thing that they knew for certain is they wouldn't have to pay our attorney fees. And that is true applying the new rule as well as the old rule. So briefly on the JNOV, I'm going to mostly rely on my briefs, but I did want to highlight that this article about 98% accuracy in diagnosing AEF when the patient has a symptomatic presentation, their plaintiff's treating cardiologist, Dr. Wong, agreed that the fact that his paralysis was transient and had resolved when he presented to the ED meant that this made him asymptomatic. And that's exactly why Dr. Wong, again, his treating cardiologist, the one who did the ablation, the one who knows the most about ablations, he didn't order a chest CT for Mr. Wolak. He ordered a head CT because he was concerned about the paralysis. He was not looking for an AEF. Dr. Wong also testified that the bubbles, which is the only thing that would have been found on an earlier CT scan to indicate AEF, the bubbles can dissipate. Of course, we're not talking about, well, an earlier CT scan would have shown this broken bone that was clearly broken at the time and remained broken. We're talking about looking for bubbles, the most transient, ephemeral thing on this earth. So I think the notion that it's not speculative to say, oh, well, an earlier scan would have shown bubbles is inconsistent with the evidence and the medicine in this case. And that's why we're asking for JNOV or a new trial on the medicine. The prejudgment interest statute. I'm not picking on you, Judge Redford, but you are also the one who is involved in Otgen, which is the only opinion, surprisingly, that talks about this requirement that the defense has to allow access to all medical records within the notice, within 56 days of the notice of intent. So in Otgen, the portion that was not subsequently overruled by the Supreme Court, this court, in my view, found that the plaintiff had to show prejudice from a failure to produce all of the medical records. And I think that's because the law requires access to the medical records. It doesn't require a perfect or complete production within 56 days. That's a tall order. And there's no evidence in this case, despite the offhand insinuation that we were somehow withholding the disability form, that we intentionally failed to provide it with our production. It was saved in a different part of the EMR system. It was not included when the request to print the medical records was made. So it's certainly something they knew about. They knew that Dr. Grishevich had found him fully disabled. They quoted from the forms in their case evaluation summary. So tell me how they didn't have the forms that they were able to quote from them. That's interesting. What Otgen kind of gets to is that applying, or what they don't get to, because the context wasn't the extra prejudgment interest, it was whether the plaintiff has more time for the affidavit of merit. Applying prejudgment interest, extra interest, is a punitive measure. So that's why the prejudice argument and the intent argument makes sense. It should be evaluated under a rubric for a discovery sanction where you look at prejudice, failure to produce other records, whether the failure was willful or accidental, because it's the same kind of thing. It's not supposed to be this gotcha, you left one page out of the 10,000 page production, so we get 6 extra months of interest. Because as I pointed out in our reply brief on cross appeal, plaintiff has a similar requirement, and I don't think they want plaintiffs to have that enforced against them. So there's no prejudice here because in their view, the absence of the forms made the case evaluation award lower. What does that mean? It means it's easier for them to get sanctions if sanctions had been available because the case evaluation award was not that high. And then the final issue, I also won't address the caps, but the final issue I wanted to talk about was the post-trial expert fees of Dr. Paranjpe. I know there was an interim order saying we agreed to the fees, but the trial court was free to revisit that, and the parties weren't free to stipulate to expert fees that aren't allowed by statute. And there's no evidence that those fees from Dr. Paranjpe for the work he did after the verdict were allowed by statute. So for all of those reasons, we would ask the court to reverse and remand for judgment or new trial. Thank you.
Your rebuttal time begins.
Thank you. A couple quick points. Court asked on the past medical expenses, how do we know that it wasn't otherwise included in the verdict? And I understand the concern.
Not form, amount.
Well, the inference from the court was that it could have been included in one of the questions submitted to the jury.
No, I'm sorry. That was not what I meant to
Okay,
imply.
all right.
What I meant to imply is you had a general type of interrogatory to the jury about what to include. How do we know they didn't include it?
Well, okay. I think I'm still on the same page. I got you. How do we know? Because there was no jury instruction on it. There was not a separate question in the verdict form on it. There was no argument about past medical expenses. It was not at issue before the jury at all. That's the best answer I can give you. And the jury had been stipulated. So matter of fact, the jury instruction that would have applied, I think it was either 50.01 or 50.04 or 5. The one deals with reasonable and necessary, was actually withdrawn by defense counsel. So the jury wasn't instructed on it at all. It wasn't an issue during jury deliberation.
Thank you.
That's the best answer I can give you. And I think that's a fairly salient point. Couple points on the JNOV. I think it's important to understand Dr. Lackey's testimony. When they actually went in and saw the fistula, and albeit too late when they did the surgery, you had testimony from Dr. Lackey that it was really well defined. This was not a situation where you would have taken a chest x-ray and you would not have seen it. His testimony was clear. He says that was very well defined. It's like a tree trunk in there. So quite frankly, given that finding that occurs when they actually
Tree trunk reference to his esophagus?
No, it's actually to the fistula.
Okay.
The connector between the esophagus and the heart. Well-formed, circumscribed structure with clean edges, and you can tell where it started and it stopped. So that testimony alone, again, would defeat the JNOV. Case evaluation sanctions. I think that Judge Mattis did not address all of the elements, and in all fairness to him, I mean, at an absolute minimum, it's got to be remanded and for reconsideration or consideration in light of Webster. He did not, I don't want to repeat what I said before, but there were certain elements that he just didn't address. And two, what he did address is number one, again, with respect, he found that RAD in footnote number 1 of the opinion was binding. And if he found RAD was binding, then RAD, as I understand it, would just simply say if the trial was after the effective date, you don't get the sanctions. I think that's what RAD held under the circumstances.
And I think that is a great argument if he ended his analysis there, but he was smart enough to know, oh, this is Redford. We better move on. And so then he really worked through it because Judge Mattis is an exceptionally bright person. And I think if he would have just left it there, I think you've got a lot, it's a lot stronger argument, but he does then go through a lot of that which the Chief Justice suggests we need to go through or holds we need to go through.
Agreed, but he did take from RAD the notion that reliance couldn't be on the fact that you were going to obtain case evaluation sanctions under the old rule. Judge Mattis discarded that. Webster embraces that. And that's a huge issue.
Okay.
So, and also I do not believe, last point, famous last words, last point, I don't believe he addressed the gamesmanship issue at all. At all. And Webster did. Webster went down the fact of, okay, who made all the motions to adjourn? Who pushed the trial off after the effective date? What was happening during negotiations during that period of time? Webster goes into all of that. Judge Mattis, I agree, is a very good judge. Don't get me wrong. He didn't go into any of that. So he has matters that were not addressed, that matters in Webster that you have to address that he did not address. So I don't think that his analysis, even hypothetically, if it was valid, is complete. So I'd ask the court to reverse on his decision, alternatively to remand for a consideration of the case evaluation same issue in light of Webster.
What about the prejudgment interest? Could you just talk about that for a moment?
Yes, I think the Wade case governs. I think that what Judge Mattis found was that this was a medical record that was not turned over. He also found that the statute is strict liability. It's not a matter of whether there was prejudice, whether there was intent, whether there's anything along those lines. When you look at the interest statute, 601311, any reason that it's basically a strict liability type statute. You either turn over all the medical records or you don't. If you didn't, then the prejudgment interest accrues from the earlier date, which is the notice of intent. So far, so good. And what he did is he said, I looked at the statute. It says shall. Okay, there's no discretion in that regard. And there's nothing in the statute that says about prejudice or good faith or anything along those lines. So he applied the statute as read, and I believe that he applied it correctly. Thank you, Your Honors.
Thank you.
Thank you.
Thank you.
Thoroughly argued, thoroughly brief, that's for sure.
you.
Thanks. Appreciate everybody's work.
And the case is submitted. We'll move on to item number 8, docket number 373332, People of the State of Michigan versus Adele Nipper. I think, Mr. Simon, you're about to earn a frequent flyer award as we continue on.
Yes, he is.
So,
Good afternoon, and may it please the court, Jonathan Simon on behalf of Mr. Niker.
Niker.
I believe the
Oh.
H is silent.
okay.
This was a situation where Mr. Niker was good friends with complainant's boyfriend, Nick. They would frequently all three hang out together. The evening in question, complainant had a fight with her boyfriend. She calls Mr. Niker, invites him to a bar. They drink, they close down the bar, they go back to his apartment.
You're leaving out some steps. There was somebody else at the bar with her, right?
Yeah.
Another longtime friend, and then defendant leaves, and then she contacts him and says, hey, and they both go over there, her and her friend. And then she falls asleep on the couch.
Well, yes, in the end, though, there is some sexual conduct. And the defense all along was that it was consensual. There was a lot of voir dire about consent. There was cross-examination.
First, the defense was nothing ever happened.
Well, yes,
What he told the police, right?
yes, that's correct.
And then he said, you shouldn't believe her that it happened. There is reasons to question her credibility.
In
And
voir
the-
dire,
Yeah, and the court, there were, during voir dire, they did, there was certainly talk about consent.
also, there was a lot of cross-examination about text messages, calling each other bro and sis. And that's attempting to establish the consensual relationship. The fact that, she comes back to his apartment, things of that nature. So at this,
with somebody else
yes, who then left?
after she was asleep.
Yes. So then, counsel apparently believing that he had established enough evidence of consent to generate an instruction to that effect, counsels Mr. Niker to waive his right to testify. Defense rests, and then at that point, counsel asks the judge for a consent instruction. Judge says, "No, I haven't heard enough evidence." Counsel says, "Well, then I'd like to recall my, withdraw the waiver of the right to testify." Judge says, "No, that's a waiver." Okay, so he's already waived that right, and no, he cannot testify. So then we have to go to closing, and we end up with a conviction. So that generates, I guess, three different arguments. One is that there was enough evidence of consent such that there should have been an instruction.
Okay, well, tell me what it is, because I don't see it.
Well, evidence that they had a friendly relationship, evidence that they called each
Okay.
other bro and sis, that she came
Well,
back to his apartment.
that doesn't work in your favor.
Okay,
I don't
well,
think,
moving
I
on.
don't think that
Moving
you want to
on.
go, that you want to make that suggestion,
Okay.
but go ahead.
Okay, but then, the judge, I think, should have allowed Mr. Niker to withdraw his waiver, allow him to testify, because that was the consent defense, which the judge ruled had not been put in enough evidence to show or to satisfy to his opinion enough evidence to generate a consent instruction. Judge says no. So we believe that that's an abuse of discretion. But
So let's play it out. You call him and you put him on the stand, and he's going to get cross-examined to no end about, you told the police nothing happened, you never touched her.
yes, and he would have to address that, to be sure. But he would also be able to say that, okay, well, maybe I was wrong. Maybe there was some sex, but it was consensual. And so, but at the very least, I think counsel, if there was any question, any doubt, any reason to believe that there may be insufficiency in order to generate the consent instruction, perhaps should have asked for an advisory opinion. Judge, at this point, or maybe, and very often I see that there's an instruction conference even prior to the resting of the defense. Very often, when the jury is excused for the defendant to state that he would be waiving his right to testify, there's also a review of the instructions. And at that point, the jury doesn't even know that the defense has rested. And so at that point, there's no prejudice. There's no reason not to allow the consent to the waiver of the right to testify to be withdrawn, allow him to present his defense, which, as Your Honor has noted, would be subject to a lot of impeachment, but nevertheless, it would deny doing us otherwise, I think would deny him a right to present a defense.
You think that let's assume that what you've said is correct. Is there a possibility that the offense as instructed communicated to the jury that because it's a forcible, that there had to be no consent?
Well, they talk about force or coercion, which is an element, but they don't bring out the consent aspect. I think that's what the consent instruction is for.
Does the consent instructions say there is some evidence of consent it is the people must prove beyond a reasonable doubt that the complaining witness did not consent. Is there, it's been literally over a decade since I've given the instructions. So, do you know? Because I just don't know right off the top of my head.
I'm sorry, do I know what?
Is if you got the instruction that you wanted, what does it say?
Well, that would have put the burden on the prosecutor
Okay.
to disprove.
Yeah, so you have to, it's like any other defense. You got to disprove it beyond a reasonable doubt,
Right.
like self-defense.
That's right.
Okay,
And so
okay.
the lack of that instruction, I think, alters the prosecutor's burden. There's another issue also. I went straight to the three which are interrelated, but the initial issue is that before the trial began, there had been a witness who presumably would have talked about other
Right.
acts, and there was no other acts notice given. And so counsel did, I think, in the form of a motion in limine, say, well, look, there's no witness, there's no notice. Can I get an understanding here that there won't be any other acts evidence? Yes, okay, fine. And then the prosecutor later asks the complainant, well, why did you come forward? And she says, well, because I know that he's done this before.
I know he has tried to do it with other people.
Okay. And so that I think is not only,
Well, and
Resist-
what happened as a result of her saying that?
well, the mistrial was denied.
But there was an immediate objection. The objection was sustained and the jury was told to disregard.
And I know that the jury is presumed to follow instructions, but it seems to me that that's a bell that you just can't unring. I mean, they hear now that he's done this before. All they're left with is that, okay,
Not
well,
that
it
he
looks like
did
he's
it, but
done it
he
again.
tried to do it.
Yes. Tried to do it before. But I think it's a glaring violation of that agreement, that understanding that was made before the trial even began, that there would be nothing about other acts. And there it is, right out of the bat from the complainant's mouth, asked by the prosecutor. And I know that I think technically it may be an unresponsive question because the prosecutor didn't technically ask her, has he done this or have you heard about other people?
That would be a bit more problematic.
Yes,
Yes.
but I think that the result is the same. I mean, it brings out, why did you come forward? I don't know what other answer he was expecting.
Was that on direct or redirect?
It goes on direct.
Okay.
Sure, Ms. Stone will correct me if I'm wrong. But I think that those four issues, or actually maybe two, if you want to look at the consent as all parts of one single issue, I think for either or both reasons should generate a new trial. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Ashley Stone from the St. Clair County Prosecutor's Office on behalf of the people. I guess in response to the very last comment, it was on direct. And in an interesting turn of events, I was also in fact the trial prosecutor for this case. On direct, that question, we've argued in our brief and I stand by, was, I should say the witness's response was non-responsive. I think looked at in context, that line of questioning was designed to ask the witness about her somewhat delayed decision to report, because the jury at this point had heard that it happened, the assault had happened somewhere around, I can't believe it was, cannot remember if it was 2 a.m. or 4 a.m., but the victim had testified she had looked at the clock in her car when she left Mr. Henniker's apartment. She knew sort of exactly around the time that it occurred. And then she doesn't not make a report until well into the next day. And she had testified to things about feeling disgusting, about having to go to work, about talking to another friend, and being very emotional about the things that happened. And so the question was designed to offer the victim a chance to explain why she waited, or that it wasn't motivated by, I guess, out of spite or an effort to get him in trouble. And I think that that's evident from the record. And I think, as Judge Letica pointed out, was immediately objected to, was immediately stricken and corrected. And then the reference to he tried to do it to other people or tried to do it other times was never brought up again at any other point in the trial. There was no other acts evidence presented. That question wasn't revisited. I just don't see that it was the trial court abused its discretion in denying the motion for a mistrial in that particular case. I think it was a non-responsive answer and it wasn't used or highlighted, and that the curative instruction was enough in terms of that particular issue. I also disagree that the defendant was deprived of his right to present a defense regarding the consent instruction. I really do not feel that the consent instruction would have been applicable in this particular case. The consent instruction is somewhat of an affirmative defense. Preliminarily, the instruction will tell the jury that the defendant has to put forth sort of the evidence of consent, that the prosecution doesn't have to begin by proving non-consent. And I think that's important because when you look in here, what you have on the record is the defendant saying it never happened, him maybe pivoting to saying she's a liar. And granted, the idea that the victim's liar is probably mostly brought out through cross-examination by trial counsel versus statements of the defendant himself. And then importantly, at the time that the assault happens, the victim is asleep. And so when you look at that, I think as the trial court did, it's really hard to say, even if they had some series of text messages or long-standing friendship, that translates to consent in this particular moment when she wakes up to him on top of her, attempting to penetrate her. I just don't see that there was consent based on any of these facts. And so in terms of it being ineffective assistance of counsel to not have the defendant testify, I think that's a real balancing act, as this court's already noted. Had the defendant testified to put, some evidence of consent on the record, he was going to be cross-examined extensively about the fact that he first just said nothing happened, that he changed his stories, that he would have had provided inconsistent statements, that he had asked if his DNA would be on her, and he said no. I mean, really, I think trial counsel had to make an evaluation about what was worth it in light of the conflicting statements that his client had already given. And so I don't think that it was ineffective assistance here to not have defendant testify. I think he had to balance sort of that exposure for his client. And lastly, it wasn't mentioned here, but again, I'll rely on my brief for the third issue that I think OB8 was properly scored for captivity. Are there any questions I could answer for this court?
What about counsel was ineffective for advising him to waive his right to testify without first seeking an advisory ruling on the consent instruction?
I think it's maybe where my comments about, balance goes to. I don't think it was ineffective to advise his client not to testify. I think there's a reasonable strategy that says, let's try to prove consent based on your history, based on these text messages, that it didn't get over the threshold was I think a strategic risk to run, because if you have him testify about this is consensual, he's going to be, he's going to have to face cross-examination about the statements he made to law enforcement that nothing happened. He's going to be cross-examined about the fact that she says she was asleep when this happened, that he prevented her from leaving, cross-examined about the fact that he said his DNA would not be on her, and it in fact is.
In two places.
I'm sorry.
In two places.
Correct, Your Honor. And so I think when you balance consent's hard, right? It essentially becomes credibility. He says, she says, when you talk about a consensual encounter between adults, I think you balance that risk against what was, I think, a very high probability that testifying was going to go poorly for this defendant, given the statements he had already made and some of the other evidence in the case. So I don't think it's ineffective to advise him not to testify. And in terms of asking the court on an advisory opinion for a consent instruction, I don't know that that's really, I guess in some ways really possible, because the consent instruction is given depending on how the proofs come out. There was a chance this victim says, well, maybe I did consent, maybe on cross-examination for the first time, she says something unexpected. The court's not going to know how to handle that. The court would have to give that opinion based on what he thought what the defendant's testimony was represented to be from trial counsel. I mean, there's a lot of ifs and speculation when you're asking for sort of an advisory opinion on consent, and consent instruction is so fact specific. I don't see it being ineffective to not ask for that. I also think it's unlikely, based on my experience in this particular courtroom, that the trial court would have agreed to offer an advisory opinion. Judge West often will hold rulings in abeyance or say, well, let's see how the facts come out and things like that. So I think it was unlikely that you were going to get that instruction just based on the nature of the consent defense in this particular trial court as well.
Is there, even if we were to say counsel's performance was deficient, can we say that there's no reasonable likelihood of a different outcome given all the other evidence in this case?
My position would be yes, that even if you say maybe you should have asked for the instruction or done something differently in terms of his client's testimony, I don't think you get to prejudice because of all of the other evidence in the case. The facts in this case about, frankly, the victim's testimony about what occurred was consistent with her SANE examination. It was consistent with the DNA evidence at trial, and it was her version of events was consistent with the other witnesses in the case. I think the defendant coming forward and putting forth what would be now a second or third contradictory statement about what occurred was not going to outweigh her consistent testimony that was corroborated by the other evidence enough that it would make a difference in the trial. Seeing no further questions, I will rest. Thank you, Your Honors.
Rebuttal, Mr. Simon?
Yeah, I was not suggesting that an advisory opinion should be sought at the outset. Affirmative defense instructions are never given in preliminary jury instructions. It depends on how the evidence comes through. I'm talking about.
My sense was you were saying before proofs were rested, you think the defense counsel should have said, hey, Judge, we both submitted proposed jury instructions. They include consent. Am I going to get consent? Just want to confirm that before my client makes final decision.
Correct.
Something along those lines.
It seemed as though Ms. Stone may think that I was suggesting that it should have been in preliminary instructions, which prior to preliminary, which is not the case. This would be prior to resting, prior to waiving the right to testify, when all the prosecution evidence has already been presented. And so I think at that point, it might have been incumbent upon counsel to seek that advisory opinion.
Great.
Thank you.
Both. The matter is submitted. Okay. Item number 9, docket number 373-281, People of the State of Michigan versus Adrian Cole.
Good afternoon, Jonathan Simon, on behalf of the defendant, Mr. Caldwell. I believe that my brief adequately sets forth the arguments which I would like the court to consider. The people did recently file a reply. I have nothing to add to that, and I ask the court for the relief which I've requested.
Any questions?
Let me just take a quick look at my notes. Sorry.
That's fine.
Okay. No questions. Thank you.
All right. All right. That matter is submitted. Thank you, Mr. Simon. And here you are again, item number 10, docket number 370753, People of the State of Michigan versus DeJohn DeMarcus Roland Johnson.
Good afternoon, Jonathan Simon on behalf of Mr. Johnson. Again, I would stand on the brief. I do note that the people agree that count 13 should be vacated.
Right.
Now, there's 3 counts of felony firearm. They're all concurrent with each other. And this would make 2 counts of felony firearm. And I understand that if he's ever charged with another gun case, it would still be a third offense. He'd still be looking at 10 years. So there's no difference in the sentence here. There's no difference in a potential future case, which he may or may not look at in the future. But in the interest of accuracy, and because the people agree, I would ask the court to remand for an amendment of the judgment of sentence.
Any other questions?
Not for me.
I see none.
Mr. Simon, thanks for taking all the cases.
Thank you,
Appreciate it.
Thank you, Mr. Simon.
Yeah.
All right. With that, we'll move on to item number 11, docket number 379318, N. Ray M.D. Foster. We had Ms. Miller endorsed. She has not checked in. And since this was on the 11 o'clock call and it's now almost 1 o'clock,
She did not reserve for Zoom, did she? Or to?
no.
Okay.
No. We'll go ahead and submit the case. We'll move on. I'm assuming the same thing's going to happen here. We'll call item number 12, docket numbers. It's a consolidated case 379-635 and 379-636. In Ray Harrison, McDonald, Purdy, minors. Again, Ms. Miller is endorsed for oral argument. This was an 11 o'clock case. It is now almost 1 p.m. and she has not checked in, so we're going to submit that on the briefs. We'll move on to item number 13, docket number 378-609 in Ray Gall. No one is endorsed for argument. That matter will be submitted on the briefs. And finally, item number 14, docket number 379-251 in Ray Stevens. That matter again, no one is endorsed for oral argument and will be submitted on the briefs. That concludes our call.